Morning, everybody. Hey, Parallax, how you doing? Spurgy, that's awesome. How you doing? Yeah, waiting for the start. Um, I will be right back in 1 second. All right, guys, I am back. Hello, good morning, everybody. Yeah, Jules, Duchess Jules, hello. Lori, hello. Toxic, hello. Cameron, yeah. Hope everybody's having a great day today. We're gonna do the closing arguments for Anthony Todt. Matthew, how you doing? Good morning, everybody. Yeah, after the dumpster fire of yesterday, we'll see what happens. Um, I have to head into the office today, so I'll be listening to closing in the car. So you guys might hear me as robot mode, but I have to because I got to get some stuff done. I got to get a lot of stuff done actually today. Holy cow! Um, but yeah, hey Critter, hey 4M. So if recapping from yesterday, Anthony took the stand and absolutely crashed and burned. I mean, ooh, wow, that was bad. That was an example of why you don't take the stand, guys. I just want to warn you. Um, you don't want to. Um, yeah, you just don't. You don't do it that way. Whatever he did, do the exact opposite. Um, so, oh yeah, thanks, Spurgy. I appreciate it. Um, so yeah, he ended up crashing and burning yesterday. So his attorneys they rested after that, which probably was the best thing because nothing was coming back from that disaster. He then asked for lesser included offenses to be included. Sounds like the manslaughter counts will be allowed, based on what's been said so far. He's denying he actually did it. So even though he has a confession of saying it, but he comes into court and says I didn't do it. I agree with the state that he's effectively denied committing it, so there's no evidence for manslaughter. Court disagrees because he said he actually killed him already in other admitted evidence. So it'll be up to the jury. I think this judge is trying to avoid appeal issues by giving the defendant more leeway, more benefit of the doubt than he should be entitled to. But that keeps the judge from getting hammered down the road, which, believe it or not, judges are worried about that. They'd rather give a guy they know is going to be toast a little extra leeway so the case doesn't come back. So we're going to hear that nonsense. And, oh, hold on 1 second. I have a call I got to take. Okay, guys, I am back. I'm sorry about that. Uh, Matthew, you brought this up about wanting to go to the bathroom. Uh, I've never been to the Franklin County Courthouse, but it's a big enough one, and yeah, I've been to courthouses all over Ohio. There's a bathroom in the jurors' room. Like there's a door. They have their own separate bathroom. That way, they don't interact with the outside world. It limits contact. Um, if let's say the courtroom Judge Holbrook was using, the bathroom went down, they would switch them to another jury room where it had an operating toilet. They do everything they can to minimize contact with the outside world. Even with the bailiff or the court's judicial assistant, going to the bathroom is not something they will waste time on. Yeah, good morning, everyone. Hi, Pauline. Simpin ain't easy. Yeah, thanks for popping in. I can tell you, you'll watch it. It'll be pretty good. After he's done testifying, there's nothing else really they talk about that's really interesting. So you can probably get away with skipping that part unless you want to see them argue over jury instructions, which I assume they're going to do in this morning a little bit as well. So yeah, that's really it right this second. Fun times, everybody. Fun times. Let's see here. I got an email. Ooh. Yeah, sorry, I got a call from a court I had to take. When they come calling, you usually answer. um, so I will just mention tonight we will be doing the normal live stream. We're back again, so we'll be doing that. Uh, some of the things we'll probably be talking about. If you guys want to talk about Johnny Depp, we could talk about it briefly. I mean, there's other people covering it. Illegal Bites is covering it. She's doing a great job. Recada's covering it. He's doing his thing on it too.
The parties to give closing statements if they wish to do so.
Oh, here we go.
Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I'm about to give you. Statement of charge. Anthony John Todt, the defendant in this case, has been accused of the crimes of murder, first degree, murder, first degree, murder, first degree, murder, first degree, and cruelty to animals. Introduction to homicide. Anthony John Todt is accused of first-degree murder in counts 1 through 4. Murder in the first degree includes the lesser crimes of murder in the second degree and manslaughter, both of which are unlawful. However, a killing that was excusable or that was committed by the justifiable use of deadly force is lawful. If you find Zoe Elizabeth Todt or Alexander John Todt or Tyler John Todt or Megan Denise Todt was killed by Anthony John Todt, you will then consider the circumstances surrounding the killing in deciding if the killing was first-degree murder or was second-degree murder or was manslaughter, or whether the killing was excusable or resulted from justifiable use of deadly force. Justifiable homicide. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. Excusable homicide. The killing of a human being is excusable and therefore lawful under any of the following 3 circumstances. 1, when the killing is committed by accident and misfortune in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent, or 2, when the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation, or 3, when the killing is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. A dangerous weapon is any object that will likely cause death or great bodily harm if used in the ordinary and usual manner contemplated by its design and construction. An object not designed to inflict bodily harm may nonetheless be a dangerous weapon if it was used in a manner likely to cause death or great bodily harm. Great bodily harm means great, as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. I now instruct you on the circumstances that must be proved before Anthony John Todt may be found guilty of first-degree murder or any lesser included crime. Count 1, murder, first-degree, Zoe Elizabeth Todt. To prove the crime of first-degree premeditated murder, the state must prove the following 3 elements beyond a reasonable doubt. 1, Zoe Elizabeth Todt is dead. 2, the death was caused by the criminal act of Anthony John Todt. 3, there was a premeditated killing of Zoe Elizabeth Todt. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. Count 2, murder, first degree, Alexander John Todt. To prove the crime of first-degree premeditated murder, the state must prove the following 3 elements beyond a reasonable doubt. 1, Alexander John Todt is dead. 2, the death was caused by the criminal act of Anthony John Todt. 3, there was a premeditated killing of Alexander John Todt. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. Count 3, murder, first degree, Tyler John Todt. To prove the crime of first-degree premeditated murder, the state must prove the following 3 elements beyond a reasonable doubt. Tyler John Todt is dead. 2, the death was caused by the criminal act of Anthony John Todt. 3, there was a premeditated killing of Tyler John Todt. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. Count 4, murder, first degree, Megan Denise Todt. To prove the crime of first-degree premeditated murder, the state must prove the following 3 elements beyond a reasonable doubt. 1, Megan Denise Todt is dead. 2, the death was caused by the criminal act of Anthony John Todt. 3, there was a premeditated killing of Megan Denise Todt. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. Count 5, animal cruelty. To prove the crime of animal cruelty, the state must prove the following element beyond a reasonable doubt. Anthony John Todt unnecessarily killed an animal, to wit, canine. When there are lesser included crimes or attempts, in considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which he is accused, there may be evidence that he committed other acts that would constitute a lesser included crime. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crimes indicated in the definition of the crimes are: as to count 1, murder, first degree, Zoe Elizabeth Todt, murder in the second degree, and manslaughter. As to count 2, murder, first degree, Alexander John Todt, murder in the second degree, and manslaughter. As to count 3, murder, first degree, Tyler John Todt, murder in the second degree, and manslaughter. As to count 4, murder, first degree, Megan Denise Todt, murder in the second degree, and manslaughter. Lesser included offenses, count 1, murder, first degree, Zoe Elizabeth Todt. Murder, second degree. To prove the crime of second degree murder, the state must prove the following 3 elements beyond a reasonable doubt. 1, Zoe Elizabeth Todt is dead. 2, the death was caused by the criminal act of Anthony John Todt. 3, there was an unlawful killing of Zoe Elizabeth Todt by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that: 1, a person of ordinary judgment would know is reasonably certain to kill or to do serious bodily injury to another, and 2, is done from ill will, hatred, spite, or an evil intent, and 3, is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. Manslaughter. To prove the crime of manslaughter, the state must prove the following 2 elements beyond a reasonable doubt. 1, Zoe Elizabeth Todt is dead. 2, Anthony John Todt intentionally committed an act or acts that caused the death of Zoe Elizabeth Todt, or Anthony John Todt intentionally procured an act that caused the death of Zoe Elizabeth Todt. Every person has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously instructed you. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. To procure means to persuade, induce, prevail upon, or cause a person to do something. Lesser included offenses, count 2, murder first degree, Alexander John Todt. Murder second degree. To prove the crime of second degree murder, the state must prove the following 3 elements beyond a reasonable doubt. 1, Alexander John Todt is dead. 2, the death was caused by the criminal act of Anthony John Todt. 3, there was an unlawful killing of Alexander John Todt by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that: 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2, is done from ill will, hatred, spite, or an evil intent, and 3, is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. Manslaughter. To prove the crime of manslaughter, the state must prove the following two elements beyond a reasonable doubt. 1, Alexander John Todt is dead. 2, Anthony John Todt intentionally committed an act or acts that caused the death of Alexander John Todt, or Anthony John Todt intentionally procured an act that caused the death of Alexander John Todt. Every person has a duty to act reasonably toward others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously instructed you. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. To procure means to persuade, induce, prevail upon, or cause a person to do something. Lesser included offenses, count 3, murder first degree, Tyler John Todt. Murder second degree. To prove the crime of second degree murder, the state must prove the following 3 elements beyond a reasonable doubt. 1, Tyler John Todt is dead. 2, the death was caused by the criminal act of Anthony John Todt. 3, there was an unlawful killing of Tyler John Todt by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that, 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2, is done from ill will, hatred, spite, or an evil intent, and 3, is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. Manslaughter. To prove the crime of manslaughter, the state must prove the following 2 elements beyond a reasonable doubt. 1, Tyler John Todt is dead. 2, Anthony John Todt intentionally committed an act or acts that caused the death of Tyler John Todt, or Anthony John Todt intentionally procured an act that caused the death of Tyler John Todt. Every person has a duty to act reasonably toward others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously instructed you. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. To procure means to persuade, induce, prevail upon, or cause a person to do something. Lesser included offenses, count 4, murder first degree, Megan Denise Todt. Murder second degree. To prove the crime of second degree murder, the state must prove the following 3 elements beyond a reasonable doubt. 1, Megan Denise Todt is dead. 2, the death was caused by the criminal act of Anthony John Todt. 3, there was an unlawful killing of Megan Denise Todt by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that, 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2, is done from ill will, hatred, spite, or an evil intent, and 3, is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. Manslaughter. To prove the crime of manslaughter, the state must prove the following 2 elements beyond a reasonable doubt. 1, Megan Denise Todt is dead. 2, Anthony John Todt intentionally committed an act or acts that caused the death of Megan Denise Todt, or Anthony John Todt intentionally procured an act that caused the death of Megan Denise Todt. Every person has a duty to act reasonably toward others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously instructed you. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death. Only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. To procure means to persuade, induce, prevail upon, or cause a person to do something. Principles. If the defendant helped another person or persons commit a crime, the defendant is a principal and must be treated as if he had done all the things the other person or persons did if, 1, the defendant had a conscious intent that the criminal act be done, and 2, the defendant did some act or said some word which was intended to and which did incite, cause, encourage, assist, or advise the other person or persons to actually commit the crime. To be a principal, the defendant does not have to be present when the crime is committed. Plea of not guilty, reasonable doubt, and burden of proof. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the indictment through each stage of the trial unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or a forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all of the evidence, there is not an abiding conviction of guilt, or if having a conviction it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial, and to it alone, that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you must find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. Weighing the evidence. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: 1, did the witness seem to have an opportunity to see and know the things about which the witness testified? 2, did the witness seem to have an accurate memory? 3, was the witness honest and straightforward in answering the attorney's questions? 4, did the witness have some interest in how the case should be decided? 5, does the witness's testimony agree with the other testimony and other evidence in the case? 6, did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the numbers of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. The defendant in this case has become a witness. You should apply the same rules to consideration of his testimony that you apply to the testimony of other witnesses. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. Defendant statements. A statement claimed to have been made by the defendant outside of court has been placed before you. Such a statement should always be considered with caution and weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including, but not limited to, 1, whether, when the defendant made the statement, he had been threatened in order to get him to make it, and 2, whether anyone had promised him anything in order to get him to make it. If you conclude the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. Rules for deliberation. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. 1, you must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. 2, this case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits and evidence and these instructions. 3, this case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. 4, remember the lawyers are not on trial. Your feelings about them should not influence your decision in this case. 5, your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. 6, whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. 7, your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and in the law contained in these instructions. At this point, we're going to take a break from the jury instructions, and the attorneys are going to have an opportunity to give a closing argument. Please remember that during this portion of the trial, what the attorneys say is not evidence or your instruction on the law. However, do listen closely. They are intended to summarize or give you a guide as to what they believe the evidence has shown or failed to show. Each side will have equal time, but the state of Florida is entitled to divide this time between an initial closing statement and a rebuttal closing statement after the defense has given its closing remarks. Ms. Pinnell, would you like the podium? All right, thank you, Deputy.
Good morning, everybody. The first thing I want to do is thank you for your time in this case. I know that it's been difficult for all of you to take some time out of your personal lives to be here with us today, and you've all been very attentive, so I would like to thank you for that. The reason why we're here today is control. The defendant wanted control. You heard that December of 2019 started out like every other December for Zoe, Alek, and Tyler. They had a concert on December 6th that they went to. They had an awards banquet on December 14th that they went to. And then everything changed. Sometime between December 14th and December 18th, the defendant took each one of their lives. You heard testimony from some of the 911 operators at the sheriff's office. And you had the opportunity to hear some pretty pleading calls from the defendant's own sister asking for somebody to please go check on the well-being of the family. The first call was on December 29th, and she told law enforcement The family's been sick because that's what she'd been told. They couldn't speak to the family during Christmas because they had the flu. What you learned later is that that was the defendant telling the family that everybody was sick. The defendant was using Megan's phone and Tyler's phone and Alek's phone to tell everybody in the family that they were sick, that's why they couldn't talk to them. But something in the defendant's sister did not sit right. So she called again in January. She called on January 10th. And she insisted that somebody go out and make contact with her brother and the rest of the family. What's interesting between the two phone calls is that in the January 10th call, the defendant's sister tells law enforcement that Megan believes the apocalypse is coming, and she just learned about this information. How did she learn about this information? From the defendant. Because we already know Megan's dead. So, you heard from law enforcement. Law enforcement tried to make contact with the family. Law enforcement went to both addresses, knocked on the doors, the blinds were closed. The defendant had conveniently parked the family van in front of a different building at the apartment on Longview Avenue. The defendant had started using cash and had continued to check the mail to make sure that nothing suspicious was going to lead somebody to the residence. And finally, on January 13th, the defendant didn't come to the door. Law enforcement opened the door, and that's when they discovered everything that was in 202 Reserve Place. And even when law enforcement is there, the defendant is still trying to be deceptive because he needs to keep control. He told Detective Miller something very interesting in his interview. He told Detective Miller, based upon their beliefs, they bring their children into this world, they should get to decide when they leave. The defendant wanted control. The defendant wanted control over the lives of his kids and of the life of Megan. And you heard from the law enforcement officers that found Alek and Tyler and Zoe and Megan. And you heard that initially they could not find Zoe. Could not find Zoe. Ultimately, they found her after looking through the house for 4 or 5 minutes. The defendant at the bottom of the stairs. I don't know when the last time I saw her. I think she went with you. Oh, maybe you should check the garage. The kids went to a sleepover. Megan's upstairs sleeping. The entire time, the defendant is trying to be deceptive. The defendant tells law enforcement also that he was intentionally deceptive with his family so that he could finish what he started. You heard from the medical examiner, and you heard from the toxicologist, and you heard that all of the members of the defendant's family at the time of their death had diphenhydramine in their system, which is Benadryl. You heard that smothering could not be ruled out because of the state of the bodies. If we know that Zoe, Tyler, Alek, and Megan were killed between December 14th and December 18th, law enforcement didn't go into the house until January 13th. It's almost an entire month. The state of their bodies prevented the medical examiner from doing a full investigation during her autopsy, but she was able to ascertain some key important things. She told you that everybody, including Megan, had no signs or issues with their heart or their liver. The medical examiner also told you that based upon the decomp of the bodies, that there was no more liquid blood left. And the boys both had stab wounds, but she didn't see any signs of hemorrhaging, which indicated to her that the stab wounds likely occurred after the death. And the defense attorney is going to get up here, and that is going to be the key point. You can't believe what Anthony Todt told law enforcement in the interview that you saw, because he said and was adamant that he stabbed the children before they died. And the medical examiner got up here and said the stab wounds were post-mortem. And that's why you can't believe Anthony Todt's statement to law enforcement. But how the defendant describes going into each child's room and killing each of his children is consistent with all of the evidence that was found on scene. It's consistent with, the only inconsistency is the stab wound when it occurred. Everybody's in agreement that there's a stab wound. And the defendant's adamant that they didn't die from a stab wound, they died from suffocation. So what you need to do is really look at the defendant's interview. The defendant very clearly describes how these murders happened. The defendant doesn't remember when they happened, just that they happened sometime before Christmas. That's what his interview said. Now we have some receipts and him knowing that, okay, well, I bought these BB guns after they were dead. So there's a receipt from Academy showing that from December 18th. We know that they were alive on December 14th because of their holiday banquet. The defendant is very meticulous and describes more than one time the order in which each of his children was killed, the manner in which each one of his children was killed, and what he did afterwards. So the defendant told you in his interview, you had the opportunity to see, that after doing some research about the afterlife and considering the fact that Megan was so sick. Megan's so sick, she can't get out of bed, she's frail, she has trouble walking, she's in excruciating pain, all of these things. She had a miscarriage, so she is so much in pain and so depressed that she was looking at these videos of the afterlife, and that's the way we're going to go. So the defendant also tells you in his interview that they sat the children down, including his 4-year-old daughter, and had a conversation with them about this plan, this suicide pact that him and Megan had together. He sat his 4-year-old daughter down and said, "What would you do if mommy and daddy died?" And then he came to the conclusion that his 4-year-old daughter decided she wanted to die with mommy and daddy. And the same with his 10-year-old son, Tyler, and his 13-year-old son, Alek. Then he had the children gather belongings that were important to them. And you'll see in the photographs, when you have an opportunity to take photographs back there, there is a chest at the foot of the bed in the master bedroom. And on this chest, there's some dolls that you open, and then there's a smaller doll and you open. So that's from Zoe. There is a scarf, a soccer scarf, which is from one of the boys. You'll see a photograph of all three of them with the Cookie Monster. And he displays all of these things on this, almost as if it's an altar. And He tells Detective Miller, I had the children pick out their favorite things so that we could put them there. The defendant then tells Detective Miller that we weren't really sure when we were going to do this, so we made sure we bought some clothes for Alek just in case he was alive. I bought some fishing lures just in case we decided to go fishing before I killed them. The defendant rather nonchalantly describes murdering his children. And on the day that he does this, he tells law enforcement, and you got to hear it, that set an alarm for 11:30 p.m. so that he could wake up to accomplish.
Objection, facts not in evidence.
I see the attorney's objection.
Oh. I wonder where that's going to go. So, yeah, guys, I'm actually about to head out. I got to head to my office, so I will see you guys all there. I wonder if that'll get done before I get done. Though, to be said, if I happen to, it's not like we're missing too much of the trial at this point. I forget who had asked. I think it was KLF asked about duress being used as a defense to murder. And that's something I just want to cover real quick. You cannot use duress as a defense to a homicide crime. You can't say I was forced to kill this person or they made me do it. For example, somebody puts a gun to your kid's head and says, go to the bank and shoot the bank president or I'll kill your kid. Doesn't work. You can't go kill that person and then claim, well, I can't be held liable. There are a lot of crimes you can claim duress for or necessity, but killing someone is not one that's accepted in society. That kind of goes against public interest and policy.
Set the alarm for 11:30 at night and got up out of bed, and it was Zoe first. That's what the defendant said to Detective Miller. The defendant then describes going into Zoe's room, and he describes laying there for a little while, getting up his courage. And ultimately, he rolls over on top of Zoe, and you saw how the defendant looked in his interview. That was approximately a month before or after the deaths. So that size is accurate as to what his size was at the time. And you heard the medical examiner talk about the weight of Zoe. And the defendant rolled over on top of her and suffocated her. And he described that this took about 15 minutes, but she really only kicked and screamed for about 3 or 4. The defendant then said, I put some covers on her so that she would stay warm. And I want to point out the fact that he talks about that in his interview, because yesterday you heard him say when Megan told him that she killed the children, that he goes to Zoe's room first, because everything is in the same order. So he goes to Zoe's room first, and he goes and gets a wash rag, and he goes back, and he closes her eyes and shuts her mouth with the wash rag, because it's the fatherly thing to do to make sure that she's comfortable. That's what the defendant told you yesterday. Now, after he's done killing Zoe, the 4-year-old, he goes to Alek, and Alek is upstairs. Alek is the 13-year-old boy. Alek's the oldest. He also described on the stand yesterday that Alek's the strongest. And he goes and he suffocates Alek. And how he describes it to Detective Miller is also very nonchalant. And he also indicates to Detective Miller that he stabs Alek in the abdomen. He's looking for the umbilicus or this vein that is supposed to help Alek bleed out quickly. Then the defendant goes downstairs to Tyler. Conveniently, Alek and Tyler are separated. They share a room. You had an opportunity to see the photos. Their beds normally are close together, but conveniently on this night they are separated. And Tyler's downstairs on the couch. And I made sure to ask the defendant yesterday, was it a pull-out couch? Was the couch open? You know, what was going on with the couch at the time that Tyler was killed? So not only did the defendant go in there and suffocate Tyler and stab Tyler's body, but the defendant, after he moved Tyler, took the time to put the couch back, put all the cushions back on the couch, make sure everything was all organized and put away. There was a stuffed animal sitting on the couch. It looked undisturbed. Now, then after all the children are dead, the defendant decides, with Megan, according to his statement, that he's going to kill Breezy. So they put a blanket down on the master bedroom bed. They call the dog up onto the bed, and the defendant grabs the dog's snout and suffocates the dog and kills the dog. The defendant then wraps the dog in a blanket and puts it in a dog bed under the nightstand. And it was at this point that the defendant does describe this plan, and Detective Miller specifically asks him, if you had everything so planned, if this was the plan and it had to happen, and this is what you were going to do for the afterlife, why didn't you know who was going to die first? Why was there a question as to who was going to die before Megan or the defendant? The defendant then tells law enforcement that Megan stabs herself, not once but twice. And there's a bit of time between each stabbing where they're laying in bed hoping that Megan's going to bleed out and die. And the defendant is very detailed in describing everything that happened between each stabbing. The defendant says that Megan was getting aggravated because it wasn't working. She was chugging Benadryl, she was chugging wine, she was taking Tylenol PM, she was doing all of these things in an attempt to kill herself. And you heard from Dr. Nora yesterday that, actually 2 days ago, that none of the stab wounds were fatal. And ultimately, the defendant takes a pillow and puts it over Megan's head until she dies. Now, something that I want to point out to you about his testimony yesterday, because the defendant says yesterday that he came home, Megan said she killed the kids, he went and checked on each kid, and then Megan stabbed herself. And at some point, he's given her CPR. You heard from the medical examiner that the stab wounds weren't fatal. He jumps into CPR. He says the cell phones are hidden, but he doesn't call out for help. He doesn't try and get help. He describes the situation that he just comes home and all his children are dead. It's morning. And when I asked him specifically, well, did you go to a neighbor? Did you try and get help? He says, well, we live in a snowbird area, right? It was December. It was December. This would be prime time for everybody to be at their houses. It's the morning, it's unrealistic to believe that there was nobody there. And also, something that's very interesting about what the defendant told you yesterday is how he described Megan. When the defense was questioning the defendant was very emotional, describing Megan. He was describing himself as a very loving and devoted husband. He would do anything for his wife. And it made him choke up as he's describing this to you. And he was very detailed, used a lot of adjectives. But you also got to see a different side of the defendant yesterday. The defendant did not shed one tear when I was talking to him. In fact, he was pretty angry with me. And I had him describe going into each child's room and finding his children dead, something that he did not talk about on direct examination. And he was just angry. And something else that I'll point out to you is he described himself as this loyal, I'll do anything, I'll take the blame for Megan man. But something very interesting that he said is Megan killed her kids. Megan killed her kids. Not our kids, not my kids, her kids. And something also about what he says, because he kind of changed his statement. And the judge is going to tell you, well, he did tell you, that you have to look at the defendant's statement yesterday, just like you would every other witness. You have to weigh what he said with the other evidence that you have in the case. You also have to weigh his statement within it. Is his statement consistent with the rest of what he's telling you? Is his statement consistent with the evidence? Is his statement consistent? Well, we know it's not consistent with what he told law enforcement, right? So some of the things that he told you yesterday, he told you when he had first got home, Megan's shirt's covered in blood. What happened? He just came out of the bathroom. What happened? And he runs and he checks on Zoe, right? So Megan just told him, I killed our kids. This is why, because the afterlife, and she's trying to explain to him, and she's following him around because miraculously on this day, she was pain-free. Every other day of her life, she was in enough pain to kill herself and her children, but this day she was pain-free. So she's pain-free, running after him as he's checking on her children. He runs past Alek's room to Zoe's room, because Zoe's his princess, that's what he said yesterday. He sees Zoe and goes to the bathroom, gets a washcloth to close her eyes. Meanwhile, he's been told his other two children are dead. He doesn't go from child to child to child. He takes the time, he goes to the bathroom, gets the washcloth, wets the washcloth. He tells you yesterday, well, I didn't have a chance to wet the washcloth between each one. Does that make sense to you? Something that's great about being a juror is you don't have to check your common sense at the door when you come in. You get to bring it back with you in deliberation, or you get to bring it in here. And the defendant says after all this, Megan's following him around and he tells her, I just want you to get help. I'll take the blame. I just want you to get help. Because he's got to explain why he told law enforcement he did it. So I'll take the blame. And then after she stabs herself and he tries CPR, then that's when he yells out the window, but nobody answers. The defendant sat in that house for over 3 weeks with his dead family. The defendant, although he denied it yesterday, told law enforcement he went to Sarasota after they died. He's going to Academy. He's going to Publix. He's going to CVS. He's going to Walgreens. He's going to all these places, using cash at all these places. He's checking the mail. He's pulling in packages. And his family he had moved them all to the same room. He put rosaries in all of their hands. He covered them all up with blankets. He's also putting a lot of plug-ins. There's candles in the trash. There's air purifiers that are stacked in this room, and he is living in this bedroom with his dead family. And he tells you, the whole time, I was just trying to get the courage to kill myself. He had the courage to kill his 4-year-old daughter. So he tries hanging, and you saw a picture of the ratchet strap. He tries zip ties that he tied around his neck, that he cut off, that he conveniently left out in the open. He tries BB guns, he tries Benadryl, he tries all these different ways to kill himself for 3 weeks. And he also takes the time to write a typed note to leave it in case, and you'll get it, you didn't get to read it in here, but you'll get a chance to read it when you deliberate because the note's in evidence, so you'll get a chance to look at it. And during his interview with law enforcement, he uses the word "we" throughout the interview. And something that he said yesterday is he's going to take the blame. He loves Megan. He's loyal to Megan. He's a loving husband, a loving father. You know, he takes every opportunity to play with his kids because he doesn't know, when will be the last opportunity. He included Megan on everything he told law enforcement. It wasn't, I take the blame, she didn't do anything. They did it together, is what he tells law enforcement. He is the one that carried out the killings, but she's in the doorway encouraging him. There are a lot of things within his statement he said to me yesterday that are inconsistent. He describes in detail the fact that they had leftovers for dinner. The kids ate, but he didn't eat. He had a shake. He then, after dinner, gets in their family van and drives over to 211 Longview. Realizes he forgets his tools, so he walks back to 202, plays basketball with his kids. He doesn't know. The sun's still up. He didn't tell me a time. The sun's still up. He walks back with the bag of tools to 211, realizes his phone's about to die, so he sits in his van and charges his phone. But when I specifically asked him if he had a phone when he found out his family was dead, he said, well, I fell asleep in the van, but the van wasn't on, so the phone didn't charge, and I didn't know the phone didn't charge. When you plug a phone in, you know whether it's charging or not. And the defendant wants you to believe that he slept an entire night in this van with it off. So the defendant wakes up, and he realizes he's late and he's got to get back because he doesn't want his wife to be mad because he's got to do these physical therapy moves on her to help her. So he rushes back, but he leaves the van there and walks back. And he goes in the house, and that's when he discovers all of this thing. And something else that you can consider is whether the witness was straightforward in answering the attorney's questions. The defendant, I told you, we're here because the defendant wants control. The defendant tried to control everything yesterday, too. I would ask a question, the defendant would give an answer that he wanted to give, and then we would have, it's a yes or no question, and there was a lot of back and forth between both of us. The defendant was trying to ask me questions. He wants control. The state's burden, as the judge told you, is beyond a reasonable doubt. The judge told you that it's not a possible doubt, speculative doubt, imaginary forced doubt. It's a reasonable doubt. And we talked in jury selection that there's a difference between what's possible and what's reasonable, right? So how you can find a reasonable doubt, if there is one, I submit to you that there's not, is the evidence, a lack of evidence, or conflict in the evidence. The conflict in the evidence comes from what the defendant told you yesterday. Because obviously he gave one complete statement to law enforcement and a completely different statement to you in court yesterday. The two cannot be resolved. So you're going to have to decide which version you believe. I submit to you that what the defendant told law enforcement makes the most sense in this case. The defendant took the life of Zoe. He then went and took the life of Alek, then Tyler, then the family dog, and then ended with his wife. And now we're here. The state's confident that you're going to return verdicts of guilt in this case.
Thank you, Ms. Miller. Ms. Smith?
Yes, Judge. You need a minute? May it please support counsel, members of the jury. Good morning, and thank you. Thank you for the sacrifice of your time. Thank you for the attention that you've paid throughout the course of this trial. You've sat through several days of testimony, several days of evidence, and now based off that evidence, the state is asking for a conviction. But not the defense. No, we're asking that you take all the evidence, all the testimony into consideration, and return a verdict that is based off that evidence, that's based off that testimony, a verdict that's not guilty. You've heard a lot, you've seen a lot, but you also haven't heard a lot, and you also haven't seen a lot. There are holes, there are gaps, and there's reasonable doubt. Now, the things that you're left with here, the things that weren't done and what doesn't make sense, that gives rise to reasonable doubt. During jury selection last week, you heard that, and you've heard throughout the presentation of the case, and you have those jury instructions that Judge Carson was going over, that the state, because they're bringing these charges, they have the burden to prove. They have the burden to prove the case beyond and to the exclusion of a reasonable doubt. Now, that burden of proof not only applies to the case as a whole, but it applies to each of the charges that Mr. Todt sits here for today, for the deaths of each member of his family as well as the family dog. Now, members of the jury, the state hasn't met that burden. You've heard the evidence, you've heard the testimony, and the evidence and testimony that has been presented throughout the several days of testimony have not proven the case beyond a reasonable doubt. Now, a reasonable doubt is not a mere possible, speculative, imaginary, or forced doubt. A reasonable doubt is a doubt to which a reason can be attached, and we have that here. Not in an insensitive sort of way, but in a way that's the truth. Now, the judge instructed you on the elements, and you have those instructions with you. Now, when it comes to a reasonable doubt, it can come from the evidence, a lack of evidence, or even a conflict in the evidence. And specifically, the definition for the reasonable doubt that's in the jury instructions is that it's not a mere possible, speculative, imaginary, or forced doubt. However, if after considering and weighing all the evidence, there's not an abiding conviction of guilt, or if it wavers and vacillates, then the charge has not been proven beyond a reasonable doubt, and the state hasn't met their burden, so you will have to find Mr. Todt not guilty. Now, like I said, a reasonable doubt, it can come from the evidence, it can come from a lack of evidence, it can even come from the conflicts in the evidence. And I'm going to take time to kind of go through each of them and show you where I believe, or where the defense believes that there can be a reasonable doubt. Now, you've heard from several witnesses throughout the course of this trial, and you've heard from Mr. Todt as well. And in some regard, each of those witnesses in some way has some interest in this case. And that's one of the factors that you can look at in determining credibility. Now, we've heard from law enforcement, we've heard from medical personnel, we've heard from toxicologists and forensic technicians, those who are alleging the charges, who are part of the state, who are bringing the charges. Now, this case is ultimately a product of their work, their investigation, and their analysis. And they're asking for and seeking a conviction. But what they want and what the evidence has shown, they're two different things. The state hasn't met their burden throughout the days of testimony. And you've heard as well from Mr. Todt, both in the interview as well as in him testifying yesterday throughout the case. Now, you also heard when we talked about that Mr. Todt has the absolute right to remain silent. He has the right not to talk, not to testify, but he chose to do that. Now, in looking at the evidence, let's turn first to there. Now, one thing that the state said, and I'm going to agree with them, they said that the defense is going to harp on the medical examiner's report regarding the blood. And that's right, because that's one of the places that you can find a reasonable doubt in the evidence. So in terms of the medical examiner, Dr. Nara, now, Dr. Nara indicated that she did the autopsies for each of the members of the family, starting first with Zoe. And she indicated that in terms of all of the members of the family, there was that Benadryl. And that she couldn't identify or specify that it was or was not a cause of the death. She indicated that there was the homicidal violence of unspecified means that also was in connection with that Benadryl. Now, she wasn't able to determine if there was smothering or if there was a strangulation or anything of that nature in terms of each member of the family. So if the medical examiner can't rule out and give you the true cause of death, that goes towards reasonable doubt. Now, in terms of Alek, she also indicated that homicidal violence of unspecified means with the diphenhydramine, the Benadryl. In Tyler, she also indicated the same thing. And even in Megan. Now, in Megan, in addition to the dihydroxymonothing, she also indicated that there were stab wounds. Now, in terms of Zoe, Alex, and Tyler, she indicated that while there were stab wounds, there was no hemorrhaging in the abdominal cavity, which means that the stab wounds were post-mortem. Now, in terms of Megan, there were the two wounds. They were about 8 inches deep and about 1/4 of an inch apart. Now, she indicated that there was hemorrhage inside of Megan's abdominal cavity and that there was clotted blood in the soft tissue. And she indicates that those indicate that the injuries were sustained while she was alive. Now, she also indicates that in terms of Megan, in addition to the Benadryl, that there also was some ethanol, some alcohol potentially. Now, Dr. Nara, when she initially was doing the autopsies, Detective Cross told her that this was a case of strangulation. And in doing her medical exam and in doing that external exam as well as that internal exam, she wasn't able to confirm that and she wasn't able to deny that. Now, she talked somewhat about kind of Benadryl and kind of how it worked a little bit. But she also talked about the incisions. She talked about the Y and the L incision and how, specifically in Megan, being that stab wound did occur before death, typically the incision wouldn't be straight like what we had in this case, if the person was moving or if there was a hesitation. There was none of that in this case. She can't say who did this cause a stab wound, but she also did testify that if a person moved, that would cause that L or potentially that Y incision. And we didn't have that in this case. Now, Dr. Nara also talked about some of the things that she collected and ultimately ends up sending off to toxicology because of not being, basically toxicology request, hey, there was no blood, these are some things that we can use to determine levels and things of that nature. So she collected those samples from the brain, the liver, and chest fluid if it was available in terms of each of the members of the family. Now, the Benadryl, the toxicity of that, she indicates that it was homicidal violence, but she also defines what homicidal violence means. It just means the act of another person. And she specifically indicated that homicidal violence does not mean premeditation. Now, in terms of the examination following that, basically the toxicologist that was done, Dr. Nara did indicate that there was some strangulation and asphyxiation as well. And she was told about this possible suicide note and suicide pact. Now, Dr. Nara did tell you that Benadryl, it can be toxic. Yes, it's an over-the-counter medication. It can be used for sleeping and for itching. But if it's taken as prescribed, there are no toxic effects. However, If it's taken in higher doses, it can cause cardiac issues, especially in children. It can cause, it can, in some cases, also cause death. Now, she's been involved in about 12 other Benadryl autopsies where those were suicide cases, but while she said it's rare, because people typically might choose other drugs or narcotics, Benadryl could be used to not only commit suicide or cause overdoses. Now, she did consider strangulation because in strangulation cases, it will cause possibly the heart to stop. But she wasn't able to rule out strangulation due to the decomposition. Now, the depth of the knife wound, she also indicated, was very important because specifically a Y wound for a knife would indicate a thrusting, whereas an L wound for a knife indicates that the person being stabbed or the person doing the stabbing, if they're stabbing themselves, moved the knife. We had neither a Y incision or an L incision here. Now, Dr. Nara also talked about how the brain can be a good source of information. And specifically in terms of Megan's brain, there was that ethanol, which she believes means that there was some alcohol consumption before death. Now, the knife wound on Megan, she couldn't tell, like I mentioned, if it was self-inflicted or not. But she did indicate that with a knife wound for a potential suicide or stabbing, she looks to see the location to make sure it's something that they can inflict themselves. And in this case, we have an two abdominal wounds that are about 3/4 of an inch apart. Now, there was no trauma. And if there was trauma, that would be something she would look for because she indicated the trauma would be indicative of if there were signs of a struggle. There was none of that here. She also looks potentially for injuries to the mouth, because if there was injuries to the mouth, then she might have done an exam or something to the mouth to look for that. In this case, nothing, no injuries were observed to the mouth, so she didn't cut into the mouth to look for it, which could have been caused by punching or being smothered with a pillow. None of that was observed here. Now, based off of the medical exam that was conducted by Dr. Nara, she also collected those samples that she sent to the Stewart Laboratory, where Ms. Carswell, the forensic medical technologist or toxicologist, conducted the toxicology, drug, and alcohol testing. Now, the specimens she received all came from the medical examiner's office. There were the brain tissue, the chest fluids were available, as well as the liver tissue. Now, she told us some various different numbers in terms of milliliters per kilogram and things like that. But the most important thing was that the dihydroaminophene, was found in each of the kids. It was found in Zoe, it was found in Alek, it was found in Tyler, as well as in Megan. Now, based off of this, as well as in Megan, there was also that ethanol level. And basically, while they do these toxicology tests, these are things that FDLE could have potentially done as well, because FDLE does have some alcohol testing and some other things, which many other things went to FDLE because we heard from FDLE analyst Mr. Conklin. Now, there was no heavy metal testing and there was nothing else that was done because Ms. Carswell was acting essentially at the direction of Dr. Nara. And Dr. Nara was getting her information from Detective Miller, who was getting his information from Mr. Todt. Now, we also heard from Dr. Stern, who is the veterinarian, and he talked about the necropsy, or now the medical change is changing to autopsy as well for animals, to the autopsy that he conducted on the canine. Now, he indicated that the canine was severely decomposed, but he also indicated that there was a dental disease and a collapsing of the trachea within the canine, within Breezy, that was found. And Dr. Stern couldn't tell you how Breezy died. He couldn't indicate a strangulation. He couldn't indicate a suffocation. And while there was a wound, he can't say that that wound was a stab wound. Based off the position in which Breezy was found, he indicated because of her being upside down, that could have easily been just a cause of decompensation. We also heard from the forensic toxicologist, Dr. Goldberger. Now, he deals with this Benadryl toxicity on a regular basis. Essentially, his whole practice at University of Florida and the autopsies that he does is specifically on Benadryl toxicity. Now, he looks at toxicity, he looks at overdose, he looks as well at fatality. Now, in each of the brain and the liver tissues that were tested, it was found to be present. We heard that from Dr. Nair, we heard that from Ms. Carswell as well, and then we also heard it from Dr. Goldberger. Now, in his examination, this is what he does primarily on a day-to-day basis, like he said, pretty much all day, every day, whether it's doing research or doing actual testing, he's dealing with Benadryl toxicity all day, every day. And he has been for several years. Now, he indicated that he can't say that it was or that it wasn't the toxicological cause of death. He indicates that the levels were remarkable, which means that they weren't insignificant, they weren't incidental. There's something that to note, there's something to look for. They were remarkable, which indicates it's a higher level, it's abnormal, it's not a normal amount. Now, there was a finding of toxicity in each of the kids and as well as in Megan. Now, we have the medical examiner who can't say that strangulation or suffocation was or wasn't the cause of death. We have Dr. Goldberger who can't say that Benadryl was or wasn't a cause of death. So while we have an unnatural death, we can't even say what caused the death. So yes, the state is right. The defense is going to focus on that because that gives rise to reasonable doubt. That means they haven't proven the case beyond and to the exclusion of a reasonable doubt. Now, even in terms of Breezy, I know we don't necessarily have Benadryl levels or anything like that in terms of her, but that's still something that you can look at. Dr. Stern, the veterinarian, can't say what the cause of her death was either. Now, we also heard from several different law enforcement officers who arrived to the scene following well-being checks and things of that nature. Now, specifically on the day in which they made contact with Mr. Todt, they indicated that they didn't knock on the door, they just walked in. And when they walk in, they see him at the top of the stairs. And he's shaking, mumbling, incoherent, kind of stumbling as he makes his way down the stairs to ultimately talk to them for several minutes. He says he thinks Megan's upstairs sleeping and things like that. Now, he sits on the bottom stair, which is an interesting point because he sits on this bottom stair, and we saw that in the body cam video. But then later, the forensic technician, Ms. Seda, does a walkthrough of the house and finds evidence, specifically finds a receipt on this same bottom stair where Mr. Todt sat for a minute or two and talked to these various officers before he was taken away to the hospital and everything. We also heard, in addition, from these various officers who initially observed Mr. Todt at the time that they arrived to that house on the 13th and made contact with him before the bodies were ultimately discovered. They were the ones who initially saw him, who interacted with him, who were able to talk about the shakiness, the incoherentness, the way in which he was talking and mumbling and not really making sense. And after that, we also heard, like I mentioned, Ms. Seda. We heard from the forensic technician. Now, Ms. Seda responded, and she was the primary technician at the case in there. She did most of her initial processing on the 13th, but she did end up coming back on the 15th to do additional processing at the direction of Detective Miller based on his interview with Mr. Todt to look for other items of evidentiary value. Now, Ms. Seda, she indicates that she did that initial walkthrough of the house, but when she got there, there were numerous law enforcement. She wasn't really sure exactly how many, but there were several law enforcement that were on scene. They did a walkthrough with her, and they were to point out anything of importance or anything that maybe for her to focus on. They pointed out nothing, including the receipt that was supposed to be on this bottom step of the stairs where Mr. Todt sat and talked to the men. Nobody pointed it out, nobody saw it, but we walked by it. Now, Ms. Seda did various processing. There were photos entered into evidence that what she photographed and processed. Now, she indicated that she photographed a lot and she processed a lot. Now, she initially began the documentation with the exterior of the home and then makes her way into the home. She indicates that the downstairs area of the house, clean, orderly, no issues, doesn't seem disturbed at all. She talks about the kitchen being clean and minus the trash that she collects from the kitchen trash can, as well as that downstairs bathroom in the downstairs area of the home. She talks about seeing some wine bottles and things like that that were photographed but not ultimately processed or collected. And just remember that Megan, that she had alcohol in her system. So there was no testing done on this bottle to indicate was there something inside of it, was there not, whose fingerprints are on the bottle. because we later hear from Mr. Conklin a lot about fingerprints that came back to Anthony, to Mr. Todt. Now, Ms. Seda does the initial documentation of downstairs, and then she makes her way upstairs. And then upstairs, she photographs and documents as well up there. Now, in the downstairs bathroom, before she gets upstairs, she notes that basically these Glade air freshener type plugins that are in that downstairs bathroom. Now, in terms of going upstairs, she photographs kind of the railing on the way up, and we see Benadryl bottle there and a phone. And throughout the time of her collecting, she sees adult Benadryl, children's Benadryl, liquid Benadryl, Benadryl tablets or pills, and even some wall drill ultimately outside. Now, she can't really say, she thinks it was about 8 bottles total that she ends up collecting total with Benadryl. Now, the knife, and she collects various items. She talks about like 2 knives that she collects, the 2 BB guns, the knife sheath, I want to call it a ratchet strap, but the strap that she collected, and some other items. The house was fully processed. The entire home was fully processed. She talked about a lot of things that she collected, but we didn't see necessarily everything that she collected, because she also mentioned collecting some journals and some notebooks and things like that as well. She indicated that she also processed the ottoman, the note that was on the ottoman, the suicide note that the state was talking about earlier, and she was able to get prints off of that. Now, we didn't hear any testimony about any prints or whose prints were actually on this note or anything like that throughout the course of the testimony from Mr. Conklin or Ms. Seda, who was the one who kind of compared the prints and did the lift cards. Ms. Seda was the only forensic technician that went to the Longview Avenue address. And that was after she left the reserve place. So the reserve place is where Mr. Todt was initially, and then they go to the Longview address. She processes that area as well. She did another walkthrough with law enforcement. There was nothing really particular found at that location, no Benadryl or anything like that. They talk about collecting the van, processing the van, all of that. But there was no print collections that were done for the van. But on the 15th, like I mentioned in the beginning, she kind of goes back to the reserve place, to the main home, based off of the directions of Detective Miller. And at this point, the main focus is on the master bedroom. And at this point, based off of the interview, the detective is like, hey, look for these zip ties, look for this knife, look for, the red strap, these different things. Look for these BB guns, things like that. Now, we hear a lot about things that were collected, and the detective makes a point of pointing out and asking Mr. Todt, like, where did you get this from? Where did you get that from? What's the passcode for this? Which device were you using to search for it? Now, that leads to lack of evidence. We hear him ask him all these questions, but we don't hear anything that Detective Miller does with this information. We don't see any phone searches. We don't see any Google searches. We don't see anything. The state talks about premeditation and how he planned this, but there's been no evidence or documentation to prove it. If we're going based on the fact that Mr. Todt said that they researched it all this time, Detective Miller is asking him, well, what's the passcode? Well, what device was used? Did you use this phone? Where did you find this at? When did you go do this? We see nothing to back up any work that Detective Miller did to corroborate this information. Detective Miller took Mr. Todt at his word and decided, hey, my job is done. But deciding that your job is done doesn't mean that the state has proven the case beyond a reasonable doubt. What was done and what wasn't done gives rise to reasonable doubt. The blood on the knife, I think it was the black and green, the buck knife. The blood on the knife was collected, but I don't believe they indicated it was tested. And the state talks about, they made a point of pointing out this bleach bottle. Ms. Seda said there was no indication to indicate that the bleach bottle was used, that no cleanup was attempted to be done, or anything like that. The state also indicated once again that the downstairs area was clean. There was no blood on the stairs leading upstairs. There was no blood downstairs in that library nook room. There was nothing down there. Now, Ms. Melendez, another forensic technician with Osceola, she went to the hospital on the 15th and she took photographs of Mr. Todt. She took photographs of various injuries. You were able to see the photograph of him. Ms. Melendez made contact with Mr. Todt at the sheriff's office following his release from the hospital while he still had those EKG, ECG nodes on his chest and his abdomen. And she documented injuries to his hand. You can see a Band-Aid. She documented wounds on his left chest and on his abdomen. And she also took some prints from him. And then ultimately collected swabs as well. Now, in terms of Mr. Conklin, the FDLE analyst who kind of took all the DNA that was collected by either Ms. Seda, Ms. Melendez, or the fingerprint cards that Ms. West collected, and he did the comparison of those. Now, Mr. Conklin indicated that the swabs were collected from both of the knives, and basically the swabs on the handle were consistent with being from at least three donors, at least one of which was male. Because of the fact that he had basically full profiles, those fingerprints for each member of the family, he was able to indicate that each and every one of the members of the family touched a knife that was found in their house. But he can't say when the DNA got there, how the DNA got there, how long it's been there. We hear about the fingerprints that were collected from the knife and the different items, but we don't hear anything about any DNA. We know that Zoe, Megan, and Alek, as well as Tyler, were all stabbed. The only one that was post-mortem, or excuse me, anti-mortem, i.e. before death, was Megan, because she's the only one that had the blood in the cavity that would indicate she was stabbed before. We've heard no testimony about any of the blood on the knife being hers. We've had no testimony of the blood on the knife being any of the other children. Now, we've kind of gone through a rough overview, and I know throughout the course of the trial you guys were taking notes as well, so you have that to rely on as well. So we've gone through a general bulk of most of the evidence. Now, let's turn to the lack of evidence, and I've kind of pointed out some of that as well. We have these photographs of these receipts and these things. And while the state doesn't have to put forth a specific number of a specific amount of evidence, we haven't seen anything that was substantiated, like I was saying with Detective Miller. He's asking all these things about when did you do this? How long have you been doing this? For the state to try to tie it to premeditation. But we've seen nothing that would substantiate premeditation. There was a lack of evidence in terms of any disturbance from downstairs. There's no blood downstairs. There's no disturbance. The state made sure to point out that that room was neat and in order. But according to Mr. Todt's interview with law enforcement, he supposedly carried Tyler from downstairs. And according to him, Tyler is the quick one, so he had to be quick with the movement, and there was blood everywhere. But there's no blood in that room. There's no blood trailing up the stairs. There's no blood anywhere in the home except the master bedroom. And really, there's no blood technically anywhere, because the medical examiners indicated like basically all the blood had left, there was no blood in the body. So the only bedroom that has blood potentially is the master bedroom. There's no blood on the stairs, no blood in that library room. So how, if you believe Mr. Todt's statement, how was he able to stab Tyler, the quick one, and he indicated in his statement that there was all this blood, and carry him upstairs little by little over his shoulder with no blood dripping from that room through the stairs, up the stairs, ultimately into this master bedroom? That lack of evidence and that conflict in the evidence doesn't make sense. The state wants you to believe Mr. Todt's statement that he gave to law enforcement on the 15th after being released from the hospital. And they don't want you to believe what he told you about yesterday when he testified. Now, in terms of statements, there are, in the jury instructions that you have, some things that I want to point out. First, in terms of, like I was talking about, the premeditation, it has to be a conscious decision to do so and must be present in the mind at the time of the killing. The premeditated intent to kill must be formed before the killing. So the state is using all this, and Detective Miller's using all this. You've been planning this for all this time to go towards premeditation, but there's nothing to really substantiate the premeditation. Specifically, the state has to prove that Mr. Todt was the one that did these things. We've heard his testimony, and we've heard the testimony both in terms of his interview as well as yesterday about how basically it was Megan. It was Megan's idea, and as the man, as the father of the house, he's essentially taking responsibility for it. But taking responsibility for it doesn't mean he was the one that committed the act, and doesn't mean he was the one that did it. Just because he's taken responsibility supposedly after the fact doesn't change the person who committed the acts in the beginning. Now, in Mr. Todt's statements, he talks about stabbing each of his kids. His statement is that each and every one of these occurred before the suffocation, before the death. His testimony and statement to law enforcement was that there was a stabbing prior, and then there was either suffocation or strangling after that. So essentially, stab, suffocate, strangle, death. But that doesn't coincide with what the medical examiner said. The medical examiner said that each of those stab wounds occurred after death, or there would have been blood in the cavity. So the state is essentially having you pick and choose when they want you to believe the defendant's statements and when they don't want you to believe the statement. They want you to believe that he did it, but don't believe the way he said he did it because it contradicts the actual physical evidence from the medical examiner, from the toxicologist, and from Dr. Goldberg as well. Now, the lack of evidence and conflicts in the evidence, like I said, they kind of go together. Now, in terms of the weighing the evidence, or sorry, let me go first to defendant's statements, because the state is essentially, like I said, pick and choosing when they want you to believe what Mr. Todt says and when they don't. Specifically, that instruction says, a statement claimed to have been made by the defendant outside of court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowing, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including but not limited to whether, when the defendant made the statement, he'd been threatened in order to make it, and whether anyone had promised him anything in order to get him to make it. If you conclude the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. Now, you're supposed to consider his statement, and you make that determination from the evidence. So while his statement of he did it helps the state's evidence, his statement of how he supposedly did it completely contradicts the physical evidence that we have in this case. What we have is Mr. Todt taking responsibility and saying that he did it after the fact, not before and not during. After all of it was done, after his family is now deceased, he's now taking responsibility to protect Megan, to protect the family, even in death. The state can't pick and choose when they want you to believe his statement. Believe that he did it, but don't believe the way in which he said it did it, because it contradicts the actual evidence. Now, the state talked about how Mr. Todt was upset and crying during direct examination, but when she questioned him, he lost all tears. When she questioned him and was telling him, give me a yes or no, when he asked, can I explain? When she's questioning him and telling him, I want a yes or no. When she's questioning him and cutting him off when he's trying to answer the question and explain. He told you he's waited 2 years to be able to tell his story and to be able to talk. And now she's cutting him off and not allowing him to do so when he's trying to answer the question. He even asked sometimes, like, do you want a yes or a no, or can I explain? And she picked and chose when she was willing to let him explain and when she wanted a yes or no. Just like she wants to pick and choose when she wants you to believe his statement. Now, we've talked about the evidence, we've talked about the lack of evidence, we've talked about the conflicts in the evidence. And there is the credibility factor that you're allowed to look at and that you should look at, because like the state said, you don't leave your common sense at that door when you go back. You have to decide if the evidence, and that evidence is the physical evidence, the testimony, the photos, the witnesses, if that agrees with the other evidence. Now, when it comes to reasonable doubt, like I said, it can come from the evidence, it can come from a lack of evidence, it can come from a conflict in the evidence. It really only takes one. But members of the jury, it's your job to decide what evidence is reliable. You get to use your common sense. And one of the things that you should consider in weighing the evidence and determining the credibility of the witnesses and the testimony is, does the testimony agree with the other testimony and that other evidence? Mr. Todt's statement does not agree with the evidence of the medical examiner. It does not agree with the evidence of the toxicologist. It does not agree with the evidence of the forensic personnel. Now, in terms of Mr. Todt's testimony, both in the form of his statement and the form of his testimony that we've heard in court, there was contradictions. He explained yesterday why he took responsibility, why he said it, he kind of explained the progression of him and Megan's relationship from the meeting through marriage, through kids, and the various ups and downs they've kind of gone through. Now, does that evidence and testimony agree with the evidence and testimony that was presented from Dr. Nair, from Ms. Carswell, from Dr. Stern, from Dr. Goldberger? It doesn't. The state is required to prove each and every element of the crime charge beyond a reasonable doubt. That's something that we submit to you they haven't been able to do. They want you to take Mr. Todt's statement at face value, at the "I did it," to just believe what he's saying. But don't forget that instruction that we went through about what you really are supposed to look at when considering a statement. The evidence, the proof, and the testimony presented here throughout the course of the trial has not proven beyond a reasonable doubt that Mr. Todt was the one that did these things. And there was also the instruction that was given about principle, essentially where the state's saying that if Mr. Todt was acting with Megan or at her direction, that he still can be convicted. But his testimony is that Megan did it all. He wasn't acting at her direction. He wasn't acting with her or in concert with her. He came home to his kids being dead. His wife was alive, but essentially dying, stabbed herself in front of him and everything. The evidence and testimony has not been able to prove beyond a reasonable doubt that Mr. Todt was the one that did these things. The evidence and testimony shows that, okay, the DNA on the knife handle was everyone in the houses. But the blood on the knife, we don't know who it belongs to. It could have been Zoe, it could have been Tyler, it could have been Alex, it could have been Megan. That's all reasonable doubt. If it could have been, that means the state hasn't proven the case beyond a reasonable doubt. That's what you have, and I submit to you that based off of what's been presented, you won't have an abiding conviction of guilt. Yes, I understand that it might not be convenient to say it was Megan because she's not here to tell the story or anything. But to come home and to find your kids and to have to watch your wife kill herself in front of you is also not an easy thing to have to do. And it's because of this that we ask you to return the only verdict which speaks to the evidence, which speaks to the testimony that has been presented throughout the course of the testimony, a verdict finding Mr. Todt not guilty. Now, members of the jury, when I sit down, the state's going to get back up here because they have the burden of proof, so they get the last word. And while listening to them, think to yourself, because I don't get a chance to get back up here and to counter any of it, what will Ms. Smith say to that? What will Ms. Smith tell me to think about in terms of that? For each and everything the state's going to get up here and attempt to convince you of, think to yourself, what would defense say? What will Ms. Smith say to that? The state hasn't met their burden. They won't be able to fit the actual facts into the testimony and evidence presented here today. They won't be able to fit Mr. Todt's actual statements into what the true evidence in the testimony that was presented was throughout this case. And I submit to you, members of the jury, that they won't be able to fit the facts into the elements, which is why you must return the only verdict which speaks to the evidence and the testimony that has been presented over the course of the trial. A verdict of not guilty in terms of the murder of Zoe Todt, a verdict of not guilty in terms of the murder of Tyler Todt, a verdict of not guilty of the murder in terms of Megan Todt, a verdict of not guilty in terms of Alexander Todt, and a verdict of not guilty of animal cruelty. Thank you.
Thank you, Ms. Smith.
that the defense did tell you that I agree with is when you're weighing the evidence, you have to look at who has an interest in the case. The defendant has the greatest interest in how this case is decided. The defense brought up the fact that you can find reasonable doubt because the medical examiner and the toxicologist and everybody can't agree as to a cause of death, but that's not the testimony that came out for you yesterday, 2 days ago. The medical examiner told you that the cause of death was, for each one of the kids and for Megan, was homicidal violence by unspecified means with diphenhydramine toxicity. Dr. Goldberger told you that due to the decomp of the bodies, that it's hard to say because of the type of tissue that was left, whether it's the toxicological cause of death. Dr. Nora told you that she tried to look for signs of suffocation, these injuries that she would expect to see, but the state of the bodies is what has prevented her from doing that. You know why? Because the defendant kept them in the house for over 3 weeks as they slowly decomposed while he was there. That's what caused the medical examiner not to be able to look for those injuries. That's what caused the medical examiner not to be able to rule out all the potential causes of death. But she told you that the cause of death for Zoe, the 4-year-old, was homicidal violence by unspecified means. Tyler, who was 10 at the time of his death, same thing. Alek, 13, same thing. Megan, same thing. The vet, Dr. Stern, told you that the dog didn't die from natural causes, but again, they couldn't rule out suffocation because of the state of the body of the dog. Defendant wanted control. The defense also talked to you a lot about premeditation and how the state hasn't proven premeditation, but one thing that you need to understand about premeditation, that premeditation can be formed in an instant. When you look at your arm and there's a mosquito on your arm and you decide to go like this, that's premeditation. You could have went like this or you could have went like that. Premeditation doesn't have to be what you see in the TVs where it's this elaborate plan. Although we have that here. The defendant told you that he's been planning this and looking at all of these videos since before Halloween. Now, the fact that you don't have the evidence of, well, this is the defendant's phone, he went and looked at this website, and this is Megan's phone, she went, look at what you have. You have the children all positioned in the master bedroom. You have Megan in the master bedroom, you have the dog in the master bedroom, you have this altar in the master bedroom. You have rosaries in each one of their hands. And you know who's alive in the house? The defendant. There is no reasonable doubt in this case. The defendant's statement to law enforcement, yes, you have to decide whether it's freely and voluntarily and knowingly made. You have to make that decision. But there is absolutely no evidence that the defendant was threatened or forced to make any statement to law enforcement. In fact, the defendant is eager. He tells Detective Miller, hold on. I want to make sure that I get this right. I did it. Just get this over with. There is no reason not to consider the defendant's statement. The fact that Dr. Nora testified that she didn't find blood in the abdominal cavity of Alek or Tyler, I want you to also think there was no blood, liquid blood in either anybody's body because of the state that they were in. What we do know is that those wounds did not nick any major organ. What we do know is that the defendant told you how they died. He said for Alek, he was behind Alek and reached his hand around and until Alek died. And he said that he had to put a pillow between the back of Alek's head and his face so that Alek didn't headbutt him. You heard him describe how Tyler died and how they had to be quick so that Tyler didn't warn the neighbors that apparently weren't there as of yesterday. So Tyler didn't warn the neighbors because he was fast and they were afraid he was going to get away.
Laurel Avis Anderson.
And what is your business address?
It's been a while. 10921 Wilshire Boulevard, Westwood Medical Plaza, Suite 1101, Los Angeles 90024.
And you're a clinical psychologist, is that correct?
Correct.
And you practice in Los Angeles?
Yes.
For how long have you been practicing?
something. Anyway, curious to know what you guys thought. And I will say, also, can you guys hear me? If you can't, let me know. But yeah, the defense did a really good job with what they had, trying to highlight all the flaws, all the problems that were present. Do I think it's going to be enough ultimately at the end of the day? No, it's not going to be near enough. But it's good to know. It's good to know that they're trying, and yeah, it was very. I say if I didn't know any facts about the case, I say it's very convincing. But having heard Anthony Todt get up there, yeah, I think you guys said it. A couple of you guys already said it. This is it. This is just we're prolonging the inevitable. But yeah, just pointing out there's some issues with the discrepancies of how did people actually die, who killed who did what. Yeah, I think a lot of that's there. A lot of that's present. They could work with it, but yeah, I don't think the jury's not gonna see through it. They're gonna see through that, and they're gonna hold him accountable. So I think just prolong the inevitable here. So, but yeah, this is really it for now. There's going to be, everything going on with Johnny Depp, going on with Husel. It's going to be a lot more interesting. I think this jury is going to be back super quick. I don't think there's going to be anything going on here. There's not going to be, and just so you guys are aware, hold on, where'd my mouse go? My mouse died. Anyway, so my mouse is dead, it looks like. I have to get new batteries. Yeah, this... I think this is going to be a quick verdict. I don't know about you guys, but this should be super quick. I know you guys, the defense attorney, I think, had a more persuasive argument, but it's still factually, it's going to fall. I wonder how long it's going to take for this jury to come back, and certainly I'd be curious to know what your guys' thoughts are, whether it's 20 minutes, 20 seconds. Yeah, so we shall see. We shall see. Oh, it just wasn't his one flub. It's just things didn't add up. Like not having the phone and acting like, oh, well, there was nobody around. It's like you live in Florida. You don't live in the middle of like the New Mexico desert. You on the street to find someone. Yeah, 10 minutes, I think, is probably correct, Shaw. Yeah, I think that's a very correct one. I just don't. Yeah, this was not impressive. Hold on, you guys. Hey guys, do we have AAA batteries? I think so. Okay.
Yeah, there's not a whole lot of nothing to accounting. You're gonna have to probably call a vet to find it or go on Amazon.
Had to go borrow some batteries, you guys. So, if they eat first 2 hours, yeah, I mean, can you blame them? Get some lunch in you. I mean, I would too. I'd want a free lunch out of this. Well, they don't have a lot of forms to fill out because if they start with the first degree premeditated murder, that's it. there's no more. They don't have to fill anything else out. So they can. Usually, that's how that works. If they find him guilty of that and killing the dogs, generally speaking, those are the only 5 counts they have to worry about. So, probably filling out the forms now. Yeah. So, okay. If it came back too fast, they have some problems. It's going to take them at least 10 minutes to nominate their foreperson and all that. Why is killing an animal cruelty bigger in charge of killing an animal? I don't know. Florida be like that, yo, is all I can say. Florida be like that, yo. That's all I can tell you. Yeah, I think that's weird too. It should be, that's like saying attempted murder is worse than murder. Doesn't make much sense, but they do what they do, and that's what they does. Okay. So that's all I can think too. But even then, still, I want the actual killing of something to be more serious. So hold on.
Monica, I just need the email with the client
Doc
notes.
now, but I think it's an older version. You sent enough.
Sorry, guys. I'm trying to get a poll to start up. But yeah, no, we're still waiting on instructions. They have to do the last bit of instruction there. So, oh, guys, this is New Jersey calling about Michael Barrett, so I need to take this.
May be seated. Thank you. Ladies and gentlemen of the jury, we are going to return to the jury instructions on the top of page 21. Cautionary instruction. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. Verdict. You may find the defendant guilty as charged or guilty of such lesser included crimes as the evidence may justify or not guilty. If you return a verdict of guilty, it should be for the highest offense on the verdict form for each count that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charge. The verdict must be in writing, and for your convenience, the necessary verdict forms have been prepared for you. They are as follows. I'm holding the verdict forms that will go back for your consideration in my hand. The verdict form has the style of the case. It says State of Florida versus Anthony John Todt, has our circuit, the case number, and our division. Under the words verdict, count 1, Zoe Elizabeth Todt, there are 4 selections. Language after the first selection, we, the jury, find the defendant guilty of first-degree murder as charged in the indictment. Language after the second selection, we, the jury, find the defendant guilty of the lesser included offense of second-degree murder. Language after the third selection, we, the jury, find the defendant guilty of the lesser included offense of manslaughter. Language after the fourth selection, we, the jury, find the defendant not guilty. So say we all. Place for the day, month, year, and foreperson's signature. Second form of verdict has the same information at the top, and under the words verdict, count 2, Alexander John Todt. There are 4 selections. The language after the first selection, we, the jury, find the defendant guilty of first-degree murder as charged in the indictment. Language after the second selection, we, the jury, find the defendant guilty of the lesser included offense of second-degree murder. The language after the third selection, we, the jury, find the defendant guilty of the lesser included offense of manslaughter. The language after the fourth selection, we, the jury, find the defendant not guilty. So say we all. Place for the day, month, year, and foreperson's signature. Third form of verdict has the same introductory paragraph at the top. Under the words verdict, count 3, Tyler John Todt. There are 4 selections. Language after the first selection indicates we, the jury, find the defendant guilty of first-degree murder as charged in the indictment. Language after the second selection, we, the jury, find the defendant guilty of the lesser included offense of second-degree murder. Language after the third selection, we, the jury, find the defendant guilty of the lesser included offense of manslaughter. Language after the fourth selection, we, the jury, find the defendant not guilty. So say we all. Place for the day, month, year, foreperson's signature. The fourth form of verdict has the same introductory paragraph. Under the words verdict, count 4, Megan Todt. Language after the first selection, we, the jury, find the defendant guilty of first-degree murder as charged in the indictment. Language after the second selection, we, the jury, find the defendant guilty of the lesser included offense of second-degree murder. Language after the third selection, we, the jury, find the defendant guilty of the lesser included offense of manslaughter. Language after the fourth selection, we, the jury, find the defendant not guilty. So say we all. Place for the day, month, year, foreperson's signature. The last form of verdict has the same introductory paragraph. Under the words verdict, count 5. It has 2 selections. The language after the first selection, we, the jury, find the defendant guilty of cruelty to animals. Language after the second selection, we, the jury, find the defendant not guilty. So say we all. Place for the day, month, year, and foreperson's signature. Single defendant, multiple counts, or informations. A separate crime is charged in each count of the indictment, and although they have been tried together, each crime and the evidence applicable to it must be considered separately, and a separate verdict returned as to each. A finding of guilty or not guilty as to one crime must not affect your verdict as to the other crimes charged. Submitting case to jury. In just a few moments, you will be taken into the jury room by the court deputy. The first thing that you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has had a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict and to bring the verdict form back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through telephone, writing, electronic communications such as a blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you during deliberations. These communications rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions, or any other instruction I have given in the case, you must tell me by giving a note to the court deputy. Many of you may have your cell phones, tablets, laptops, or other electronic devices with you here in the courtroom. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. Kindly follow the instructions of the court deputy and your property will be safeguarded while you deliberate. If you need to communicate with me, send a note through the court deputy signed by the foreperson. If you have voted, do not disclose the actual vote in the note. If you have questions, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions, if I can, in writing or orally here in open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. These exhibits will be sent into the jury room with you when you begin to deliberate. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For 2 centuries, we have agreed to a constitution and to live by the law. No juror has the right to violate rules we all share. May I see the attorneys briefly at the bench, please?
Okay, now we're back. Yeah, it's show them where to write guilt and take time. You got me rolling, man, but no, they got to do it the right way. Yeah, how long are these? It's the same every time. Some judges break them up how they do them. This is just horrible. I know, guys. It's almost over. We'll finish this up, and then we'll get on to... Now, from here, I'm going to be doing work and stuff, so while we're waiting for the verdict. So, you guys are free to go wherever you want. So, yeah, and I have some news about Michael Barrett's from my end of it, so we'll find out. Maybe there's something I can do to law and crime tonight.
Ladies and gentlemen, a couple more instructions that I have for you. If you happen to have a smartwatch, if you will please leave that electronic device with the court deputies as well. It will be safeguarded. Finally, please remember the instruction I gave during the trial that the transcript of any video recording that you saw is not evidence and not to be considered as such. The recording itself is the evidence, and it will go back for your consideration. 2 jurors have performed a very valuable service for the state of Florida, Mr. Todt and the court as alternate jurors. I'm going to ask jurors number 82 and 83 to please remain with us in the courtroom. I will have some additional instructions for you, and if you have any personal belongings, the court deputies will retrieve that from the jury deliberation room. For the rest of the jurors, you may now retire to consider your verdict. We will compile the evidence and send it back shortly for your review, along with the jury instructions and the verdict forms. If you will please leave your courtesy copies of the jury instructions on your respective seats. They will be collected. You may take your personal notepads back for consideration. You may now retire to consider your verdict.
All rise for the jury.
Parties may be seated. Thank you. Juror number 82 and juror number 83, I don't know whether this comes as a disappointment or a relief that you will not be called upon to deliberate in this case. I want to thank you for the very valuable service that you performed for the state of Florida, for Mr. Todt and the court in this age of a COVID-19 pandemic, as well as just getting through the cold and flu season. Oftentimes on a trial of this length, one of your fellow jurors will be unable to continue with their role as a juror. If that had happened in this case, you would have immediately been called upon to deliberate in their stead. I noticed you taking notes and paying very close attention to the proceedings, and I thank you for that attention. I have an acknowledgement form that will acknowledge for each of you your 6 days of jury service. It will excuse you from further jury service for a period of 12 months, and I will have the deputies give that to you with our thanks. You'll also note that it has a business card stapled to it. If you are curious as to what the ultimate decision of your fellow jurors is, you have a couple of options. You may remain. This is a public courtroom, and you may remain to retrieve or receive any updates on their verdict as we receive them, or if you wish to give my judicial assistant a call, she will be happy to share with you any decision of the jury and any subsequent court hearings should they be necessary. You have all of the rights that any juror has. For hundreds of years, we have relied upon juries to decide difficult cases. For many centuries, we have decided that a juror's thoughts about the case should remain their private affair for as long as they wish it. Therefore, the law gives you the privilege not to be compelled to speak about your work as a juror. However, at this point, you are going to be discharged, and you are free to speak with anyone you choose about your thoughts about this case, with the exception of your fellow jurors who are now deliberating. Questions may come from those who are curious, from the media, from elsewhere. It is entirely up to you whether you decide to preserve your right to privacy as a juror. At this point, the court deputies are going to assist you through this door. Do you have any personal belongings in the jury deliberation room? You do? If you'll share that information with the court deputies, we'll make sure to get any personal belongings. I also am aware that you may have ordered lunch. You are welcome to stay, and that lunch will be delivered shortly with our compliments. Thank you very much for your service in this trial.
All rise for the jury.
Parties may be seated. Thank you. Mr. Todt, both sides of the evidence has concluded. The arguments by all of the attorneys has concluded. A jury assembled with your participation is now deciding what the facts of this case may be and applying the facts as they decide them to the laws I have given them. Are you generally satisfied with the efforts of your defense team in this case? Thank you. The response was yes, correct? Thank you. All right. Todt. That is the last question that I will have for you, pending a jury question or a verdict. We will be in recess pending the jury question or verdict. Before the attorneys are excused, if you will please verify that the items of evidence are the actual items of evidence. I will put the jury instructions from which I read and the verdict forms up for your review as well. We'll go briefly back on the record once you've had an opportunity to review those items, and then after that, the court will be in recess pending a question or verdict. We'll be in a brief recess. Of course, Mr. Wesley, thank you. Back on the record, each side has reviewed the evidence going back for the jury's consideration.
Yes, Judge.
I don't see a laptop going back. We'll show that to defense.
All right, 1 second. I reviewed it this morning.
All right, thank you. An internet-disabled laptop will go back to be able to play any electronic evidence that was presented during the trial. The deputy will take that back in just a moment. Any additional objections to any of the items going back for the jury's consideration?
No, Judge, I think the deputy was going to give him a box of gloves, but otherwise, no.
Okay, state.
Oh, okay.
All right, thank you. Court will be in recess pending a jury verdict or a question.
Are we taking a lunch recess, Judge, or just?
So the parties are aware, the jury has ordered lunch. They will be provided lunch as they are deliberating. If we receive a question or a verdict, I won't bring the parties back any sooner than 1:15.
Okay, thank you, Judge.
So, guys, that is it. We are done. Dunsky, Dunsky, Dunsky. So, yeah, as far as the notebooks go, that is up to the judge. Some judges let people do that. Some judges don't. It is really it really depends on the court. Yes, I agree with the idea of you took notes and then I'm not going to let you have them. Just seems really, really, really stupid. But c'est la vie, c'est la vie. Little Miss, I would like to talk to you. Can you send me an email? You have my email address, I'm pretty sure. Send me an email. I want to talk to you about that one because I just got the phone in the court and I got a little bit of a different answer. No, I didn't get a copy from Law and Crime. I tried getting a copy from the courthouse itself in Morris County. So, generally speaking, they don't necessarily like the first meal. They might decide to eat first, or they might work through lunch. I don't know. It's gonna be up to them. Yeah, you guys, if you want to watch Johnny Depp and Amber Heard, Twist Sisters is a good one to go to. I will see you guys in a little bit. Hopefully, we get a verdict soon. Otherwise, I'm gonna leave. I'm just gonna leave up the. I'm gonna leave this up while we're waiting. Oh yeah, Sam, you're correct. Ricade has been able to get some of them. It goes kind of bounces around. So yeah. And I gotta get in touch with him and Emily, um, see what's going on with this, see if they can help me. But we're still working on it. So I will see you guys in a bit.
Thank you. The court has received 2 pieces of correspondence.
We're waiting, Judge. We don't have the client yet. Thank you.
Got it. All right, we're back on the record. The court has received 2 pieces of correspondence from the jury. The first piece of correspondence is not signed, but it is from one of the notepads. Correspondence indicates our laptop appears to not have volume. Is the audio in the USB file muted, or can we get another computer? Either side wish to take a look at the piece of correspondence? Right. Thanks. That'll be filed with the court file. Second piece of correspondence indicates we need scissors to open packaging, and that is signed by the foreperson. Would either side like to take a look at the correspondence?
No, Judge.
Thank you. That will be filed. Received the administrative request for scissors. I approved the deputies to deliver scissors to gain access to items that were already in evidence. As to the issue of the laptop computer,
I can speak to the laptop now.
right, I don't have a. I don't have an issue with retrieving the computer.
What kind of questions do they have at this point is what I'm wondering. At least they didn't overdose on Benadryl. They're still alive. Uh-oh. Did it freeze? Frozen for you guys?
That's me.
Yes. Go to DOC. Hello, sir. Can you check the Amazon book? Can you check the library number 28, please?
The jury has been deliberating since 12:30 this afternoon. During closing arguments, the state and defense argued over how the family died and who really did.
Oh, I put the...
Yeah, we have a floater here. We got a crew coming, plus we've got the guy inside. Yeah, makes up for the lack of live truck, I guess.
Who needs the truck when you got the manpower?
Oh, sorry. I was like hopping on her because I don't have a way of. I don't have a way in. All right, then we'll move over.
Oh.
We'll go over here. We're good over here, Artie?
We should be fine, thank you.
Okay, sorry about that.
Nah, I've done that before.
We're trying to share a monitor.
Yeah.
We got a monitor right there.
Oh,
So
cool.
Evan's we're trying to share.
Oh, cool, no big deal. No big deal.
What's happening up there?
Yeah, no, I'm not mad.
The jury has been deliberating since 12:30 this afternoon. During closing arguments, the state and defense argued how the family died and who really did it. How the family died and who really did it. And again, we're still waiting to see how long the jury will deliberate. Of course, since it's Good Friday tomorrow, we're told that court will be closed, so it will resume on. We're hearing there won't be any court taking place. We're hearing there won't be any
Not us. I love the
court
unit.
taking.
It's all over.
I know, because it's Good Friday tomorrow.
Yeah.
Yeah, the jury has been deliberating since 12:30 this afternoon. During closing arguments, both the state and defense argued how the family died and who really did it. We're still watching the jury deliberate because it's Good Friday tomorrow. We're told there won't be any
Also
court.
a body language expert in case you wanted to read the jury's body language before they head in there.
Oh, is he? Very nice. We'll put a mic on you. One, two, three, four, five, six, seven, eight, nine, 10. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. There's always one of them, right? 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Can you hear me okay? Test, 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 test. So the station knows who's up, like who's hooked up to the box now? Do they know that you're hooked up to the box? Okay, thanks.
No, don't down me again. I'm trying to keep the 18 so.
Thank you.
Donata.
Speak Spanish only for Ramon.
You sound a little jealous. Hold on.
Okay, thank you.
Mute. You're welcome. Yeah, I can't even. They got the TV up, but I can't see it. The jury has been deliberating since 12:30 this afternoon. During closing arguments, both the state and defense argued over who killed the family and how they died.
I said after you get your mic checked, or did you get it already?
Yeah, it's great.
Antes de la colonoscopia.
The jury's been deliberating since 12:30 this afternoon. During closing arguments, the defense and the state argued over who killed the family and how they died. Over how the family died. Who killed the family. Or how they died. Again, wait to see how. I guess I've got the jury too.
No doubt. Right, you did. You managed. Rebecca, I need you to stand on top of the car for the last shot.
Freedom Heights.
El día de la copa. ¿Qué día es hoy? Jueves que viene. Bueno, mira, lo voy a dejar porque voy aquí y vamos a cerrar. Vale, voy a dar un beso.
We're the third story.
Sure.
Uno, dos, tres.
Yes.
Tres. How do you say story?
Historia.
Storia. Did you say hi to Mike?
Yeah.
You mean Mike?
He helped me with my police life.
Oh, okay. We worked together years ago, but I first started here, long time ago.
And he came for check if I'm good with you.
Yes. He has a daughter. He has a little girl. How old is she now? 7?
Oh, wait, never mind. She's about to be 11.
11.
No way.
Yeah. She's going in the 6th grade next year.
Just one?
Just one.
I have two boys.
But I'm the godmother.
Yeah?
Godmother.
Your princess.
Yes.
The princess of your life. Better than your wife.
Yeah.
You like
Oh, yeah.
you prepare for when she have teenager, you prepare what?
Yeah. The boys aren't going to have to worry about it.
Wow. If I have just 2 boys, if I have a girl, I will just beautiful.
Has been deliberating since 12:30 this afternoon. During closing arguments, both the state and defense argued about how the family died.
You have 5 years of
So, everybody, I apologize. This afternoon got a little crazy, so my apologies to everybody again. So yeah, it sounds like they are, the jury's deadlocked on some things. We don't know. From what I looked up on Twitter, and I apologize, only 10 of us now, they have unanimous verdict on some counts, but not all counts, so we don't know what that actually means. That could mean a lot, it could mean a little. Um, um, so, we shall see. Curious to know if you guys have any questions. I could try to... If you guys have any questions on stuff, we can try to answer those right now. I'm not sure what's going on, but yes, he lives. Thank you, Papa Bear. Appreciate it. I don't know if I hear any sound. Also, Law and Crime, I'm doing whatever I want. I'm curious to know what you guys are going to do, but I feel like living dangerously. So, we shall see what happens tonight. I may have found some interesting information out about the Bearstone trial, which, by the way, not guilty all counts, but he did go into the nut hut. So, working with the court, I'm trying to figure out if there is a jury order. Here you go, Gabby. Thanks, friend. Are you sick? So yeah, take care of stuff. Oh no, don't worry about teasing me. Trust me, I'm totally fine. Yeah, some of you guys were commenting. No, I did not get it yet. It got delayed. It comes in tomorrow. So I am trying to do that thing you told me to do and avoid touching things. So I'm really trying to not touch stuff right now. And I'm actually going to set things up to make that work. I hope that helps. Okay, good. Well, I appreciate that because I'm trying to figure out what to do to help make that not an issue for you. Because if it's you, other people are having the problem. Oh, Gixer, you missed this? Yeah, last week I got copy struck during a live stream, so I lost the right to stream for 1 week. Oh, here we go. Showtime, folks.
About 15 minutes. There's been no indication that the jury has reached a unanimous verdict on any particular count, so I'm inclined to return them. Give them some brief instructions that any unanimous decision that they have received decided upon on any particular count, it won't be final until tendered, published, and accepted by each particular juror so that every individual juror can still change their mind as to any of the counts. I'm going to read the Allen charge. I'm going to offer them dinner should they accept and give them a time frame as to how long the anticipated delivery would be for dinner, and then send them back after the Allen charge. Any requested changes to that procedure, defense?
No, Judge.
State. Let's return the jury, please.
rise to the jury.
Breaking my heart. But we shall see what happens. And guys, I
May be seated.
know.
Thank you.
Guys, look, I'm trying to talk just so they don't try to claim I'm
Welcome
not fair
back.
using it.
The court is going to amend
Okay.
the procedure that we had originally discussed. We're going to scrap the manila envelope. If any of the verdict forms have been filled out because there is a unanimous decision, please understand that that decision will not be final until tendered to the court,
That's
published
true.
and accepted by each juror. So any individual juror can still change their mind on any particular count. Please pay attention to the instructions I am about to give you. I know that all of you have worked hard to try and find a verdict in this
Go
case.
back and try again.
It has apparently been impossible for you so far. Sometimes an early vote before discussions can make it hard to reach an agreement about the case later. The vote, not the discussion, might be hard to see all sides of the case. The vote, not the discussion, might make it hard to see all sides of the case. We are all aware that it is legally permissible for a jury to disagree. There are two things that a jury can lawfully do: agree on a verdict or disagree on what the facts of this case may truly be. There is nothing to disagree about on the law. The law is as I told you. If you have any disagreements about the law, I should clear them up for you now. That should be my problem, not yours. If you disagree over what you believe the evidence showed, then only you can resolve that conflict if it is to be resolved. I have only one request of you. By law, I cannot demand this of you, but I want you to go back into the jury room. Then, taking turns, tell each of the other jurors about any weaknesses of your own position. You should not interrupt each other or comment on each other's views until each of you has had a chance to talk. After you have done that, if you simply cannot reach a verdict, then return to the courtroom and I will declare this case mistried and I will discharge you with my sincere appreciation for your services. In just a moment, you will be presented with a dinner menu. Dinner will be provided should you choose to order dinner. Dinner will generally take about 1 hour from the time that you order to be delivered, so you may order dinner should you choose to do that. You may now retire to continue with your
For
deliberations.
God's sake. He's going to give them a mistrial this early? My God. This is insane. On a first-degree murder trial.
Defense, any objection to the jury deadlock Allen charge is read to the jury?
No, Your Honor.
State. We'll be in recess pending a jury question, communication, or verdict.
Okay, well, that's, wow. He's gonna do a mistrial this early. I mean, I'm surprised. They should just start till they reach a decision. We're not allowed to do that, Gabby. There are rules. We're not allowed to do that. Yeah, I think the judge wants this done. I mean, I think part of the judge's thinking, though, is, oh my God, if they can't figure it out now, they'll never figure it out. And I think that's true. If they can't figure it out, I don't know how the hell you can at this point. Yeah, hey, Sky Queen, Critter, Gabby, Papa Bear, Matthew, George, Gixer, who else is here? This potentially criminal guy sounds good. Shaw, whoever else is here right now, guys. Thank you for sticking around and coming back in. I know it's been ridiculous, but Yeah, and I apologize. I got a little kind of lazy earlier in the afternoon, so my apologies there. Um, yeah, they're having deliberations and mistrial. Yeah, they'll try again. A quadruple murder. I don't think they won't. They're out of their minds if they give this up. Now that said, I think they might understand when there's holes in their evidence, and they might be able to present better or differently. But I think I wonder if they're tied up on whether or not he killed the kids. I think Matthew brought that up, and I'm thinking now that may be an issue. Certainly, they're not hung over just the dog. I think they're tied over whether or not she killed the kids or he killed the kids. Um, Either way, if he gets convicted of any of those, he goes away forever. So it's not too bad. Yeah, well, I mean, this is a pretty big one. Um, so yeah, I had to use Licht and Cuck for a minute because Fox 35 is not working at full speed. So, um, and I will use them again. Now that said, guys, just so you know, when it comes to it, um, I'm probably going to talk a little bit more while they're airing, just so they can't come in here and squeal and cry about my fair use. I'm going to have to do that just to protect our ass. So it's not going to be like Nick Rekieta bad, but I'm going to be talking a little bit more. I mean, he could have. Maybe he did kill the kids and the kids kill her. Not sure. I mean, I don't believe it. I don't buy it. None of his story makes sense the way he gave his testimony yesterday. I forget who it was earlier. Simpin' Ain't Easy watched it. I think he realized, he watched the testimony today. He said it 2 times. And he said, "There's no way this guy didn't do it." And I don't believe. I'm convinced he did it. I mean, his story doesn't work. It doesn't make any sense. The guy's a lunatic. This idea she was trying to stab herself to death with like a pocket knife, I don't buy. So, we shall see. We shall see. Ooh, 9 people. We're starting to climb again. Ooh, hang on tight, everybody. So I'm gonna keep this running, but my God, I can't believe they're. I mean, here's what I can tell you. I have no idea if you guys are thinking what the verdict is. I mean, I'd like to tell you it's like an 11-1 or something. I have no idea right now. This could be like a 6-6 or something. It could be a lot. I don't think it's as cut and dried as we think. There's something big brewing. Now, I'll tell you this much. If I'm on the defense side of this, I'm doing fucking cartwheels. Because this is a great sign. I mean, this is awesome. You're dragging it out. Yeah, this is giving me hope for a mistrial. If I'm the prosecution, I'm getting real nervous of a mistrial. Buffering. Am I buffering? Hold on. Sequester in hotel. You can't do that now. They have to be sequestered early on. Easter with bread and water. Jeez. No, there's one idiot. Shaw, I think me and you have been seeing eye to eye on this. I really hope you're fine. I really hope we're right. And I hope it's 100% correct, but I don't know. I'm starting to have some doubts. That doubt's creeping in on me. Well, no, Critter said it was buffering, so I wasn't sure. Anyway, so Michael Barrett-Stone was acquitted of everything. So does he go back to jail in the meantime, or what? In a case like this, he's probably sitting in a back room that they have where they can have him with his attorneys. I mean, they're all sitting there waiting around. And I actually talk about this in my, I did a video way back when I first started doing this seriously. What are you doing when you're deliberating? His attorneys are trying to keep him calm. They're trying to get ready, like, hey, what are we doing tomorrow? Thankfully, it's the weekend, so they don't have to prepare too much. I not sure. I think I fixed that. So hopefully we are. you know, he's going to be sitting in that room because he's got his suit on and everything. They probably took him back to feed him. Sadly, that's been one of the things where when I have a client who's in custody, you know, paid or appointed, you know, there's times where I'm like, hey, I want to get my guy dinner. Can I do that? And they say no because he's in custody. He has to eat the jail food. So he probably did go back and eat jail food, or they probably brought a tray out to him. Not sure how they do it in this county. But he's ate the food. But having him go all the way over to the jail and bring him all the way back, even if it's a connected building, he's going to be near the courtroom until the end of the day, and then they'll take him and put him in a suit, take his suit off and everything for tomorrow. If they're open tomorrow. Yes, now, if there's a mistrial, his bond goes, everything goes back to pretrial mode. They talk about his bond. I'm assuming he's been held without bond because this guy should be held without bond. If he's convicted of charged with 4 murders. Or at least, you know, some level of bond that he hasn't been able to meet. Yeah, he goes back to jail until the new trial starts. Just like with the Whitmer plot, the Whitmer kidnap guys, the 2 that got a hung jury, they went right back to jail. And they're sitting in jail again until their new trial. So, yeah, if that's your answer, mistrial, he goes back to jail and they start all over. If it's deliberations, they're going to keep him nearby. I hope that answered it. So, yeah, I still can't believe that we're at this point, but it's drama. So there you go. Now it's interesting. Yay. I mean, I'm thinking, I'm hoping that's the case because one idiot usually can get bullied into seeing what's right. But if it's multiple idiots, that's the danger because then they band together. He's probably. Oh, I don't think he's gonna. So Michael Berenson, we're gonna speed up on this. Spoiler alert: not guilty by reason of insanity on 2 of the counts. Not guilty on the other 2 counts. He is going to be held for a while. Being NGRI means that you're criminally insane, so you get sent to the state mental institution. They're gonna have to evaluate him. They're gonna have to do all their tests on him to make sure he's fine. It's gonna take a lot longer than 7 days. You know, I anticipate him being there at least minimum of 6 months. Maybe there's a state law about 30 days. I don't know for sure. But he's going to have to go, and it's going to be a while, and it's not going to be fun. It's going to be awful. A state mental institution's like a prison, maybe less restrictive at times, but full of crazy people. So it's just as dangerous and almost as despair-inducing. Because I've had clients go there before to get restored, and they tell you it's crazy there. Yeah, if he's only in there for 7 days, he tricked the jury? No, because at the time was he insane. It's not at the time of trial, but at the time he shot that lady, was he insane? That lady who made some false reports on him, it sounds like. So we'll see. We'll see what happened, but he's not... Yeah. Okay, so the judge said 30 days for the report, then we'll see what the doctors decide. So yeah, he's got an evaluation. Now, I have a feeling it's going to be there for a bit. So yeah, we'll find out. But it's not as simple as going, haha, they found me not guilty, and you get to eat Jell-O and watch TV all day. I mean, better than the alternative, but not by much. Yeah, I'm not sure what Long Licked and Cucked is up to right now, but they're the only game in town that's reliably showing the feed, so we will have to use them, sadly. Other than that, how's everybody else doing tonight? Was he a wreck the whole trial? From what I've seen, he probably was a wreck. I mean, think about it. You're facing going away forever. I mean, that'll get on anybody's nerves. That'll get through anybody's mind. Awesome all for Friday and Monday. Lucky you. I'm in a weird spot. I actually have a guy getting arraigned tomorrow morning. And then I've got stuff on Monday. Like, it's weird. I got court on Easter Monday and Good Friday, which up until a couple of years ago, that never happened. So I don't really understand that one. But congratulations to you. You don't have to be you until Tuesday. The jurors should use some scissors to sort out the... They should just Benadryl him and stabbed him. Yeah, use the scissors on him. Oh no, the courthouse is busy all day, so it's just this happened to be the day they decided to do the arraignments. Like, haha, we're gonna work on Good Friday. Yay. So Husel is still out, which is making me very concerned they're gonna convict him of something. We'll talk about that later. I don't want to give up all my despair now, but we'll wait. Some interesting stuff happened in the Amber Heard trial, the Johnny Depp trial. Witness got caught apparently discussing things, but we'll talk about that later. The Patrick Loyola shooting, that one's a bit it's something else. We'll talk about that one. I don't want to talk too much about that now. I'm gonna save the good, must-see TV for later. Gosh, it's like in 3 hours I gotta do that too. Jeez, it's been a long day. I think it's called Easter. Is it still called Easter Monday, Gabby? I think so. That's what I always call it, and that's what my Google Calendar says. It says it's Easter Monday. It says taxes are due. So, oh yeah, your taxes are due coming up, guys. Be ready. Get your taxes done. I don't need the IRS sending you to prison. I need you guys viewing my streams. I need the engagement. No, I've been working. I was working. I was doing stuff earlier. I sat around and said hi to Nick Ricada for a bit. I said hi to Alita and Kurt. By the way, Alita on Legal Bites got 50,000 subs. That's a pretty cool accomplishment. So if you guys aren't already subscribed to her, definitely do it. So, and I'm not going to lie, guys. I am about to keep Long Crime on my phone kind of playing low-key. And I'll come run in here and get things going if we need to. But I'm about to go eat and take care of some... You're safe from the IRS. Yes. You just have to worry about the Kingsmen coming and saying, "Oi, where's your gold?" IRS. No additional comment required. Aw, I thought you were cool. But guys, I think I'm going to take a break. I will come back to this. Yeah, I mean, I hope we're here back soon with a verdict. They drag somebody out all bruised up like Amber Heard and like, look, here's what some real injuries look like. But yeah, I can't believe they're still going. So, all right, guys. Yeah, the jury has an hour to wait till dinner. So even if they ordered by now, they're not getting dinner till 7:30. Gosh, these guys are going to run into my time. You believe these assholes? These asshole jurors. I'm trying to do a stream later tonight, and they're probably going to fuck it up. The nerve of people. The nerve. So, guys, we will see you in a bit. We'll come run in here and set the world on fire if we have to. Go eat. Go eat. I'm a fat guy. You don't have to tell me to go eat. That's not... Don't worry. I got that part under control. All right, guys. I will see you in a little bit. Yes, we're coming back on 9:30 p.m. Eastern Standard Time. So 9 o'clock on the East Coast, 8 o'clock Central, 7 o'clock Mountain Time. I think 6:30 if you live out on the West Coast. Turn your notification sound up loud. All right, guys, I'll see you. Here we are, sports fans. I
I'm
deliver.
aware that the jury has indicated they have reached a verdict. I understand this is an emotional case. If anyone feels that they may have an emotional response to the jury's verdict that is in any way disruptive,
It's going to be a split verdict. I'm calling it now.
remove
Hoping I'm
yourself
wrong.
from the courtroom prior to any verdict being published. Defense, is there anything we need to talk about before returning the jury?
No, sir, we're ready for the verdicts.
Thank you. Let's return the jury, please.
Me too. Me too.
All rise to the jury.
I'd be nervous too. Going.
You may be seated. Thank you. Does the defense recognize the presence of the jury?
Even the dogs are nervous, guys.
Members of the jury, the court has been made aware that the jury has reached a verdict. Madam Foreperson, has the jury reached a unanimous verdict? If you'll please give those forms of verdict to the court deputy. The defendant will please rise.
Drum roll.
Madam Clerk, if you would please publish the verdict.
In the Circuit Court of the Ninth Judicial Circuit in and for Osceola County, Florida, case number 2020 CF 149. State of Florida versus Anthony John.
Here we go.
Verdict as to count 1. We, the jury, find the defendant guilty of first-degree murder as charged in the indictment. Verdict as to count 2. We, the jury, find the defendant guilty of first-degree murder as charged in the indictment. Verdict as to count 3. We, the jury, find the defendant guilty of first-degree murder
Boom.
as charged in the indictment.
Wow.
Verdict as to count 4. We, the jury, find the defendant guilty of first-degree murder as charged in the indictment. Verdict as to count 5. We, the jury, find the defendant guilty of cruelty to animals. So say we all, dated at Kissimmee, Osceola, Florida, Osceola County, Florida, on the 14th of April, 2020.
You may be seated. Does either side wish for the jury to be polled?
Yes, Your Honor.
Madam Clerk, if you would please poll the jury by juror number.
Juror number 78, are these your verdicts?
Yes.
Juror number 75, are these your verdict?
Yes, ma'am.
Juror number 74, are these your verdict? Yes. Juror number 73, are these your verdict?
Yes, ma'am.
Juror number 71, are these your verdicts?
Yes.
Juror number 66, are these your verdicts?
Yes.
Juror number 53, are these your verdicts? Juror number 42, are these your verdicts?
No.
Juror number 29, are these your verdicts? Juror number 8, are these your verdicts?
Yes.
Juror number 5, are these your verdicts?
Yes, ma'am.
Juror number 4, are these your verdicts?
Yes.
The jury is unanimous.
That may very well
Ladies and
be.
gentlemen, I thank you for your time and consideration in this case. I also wish to advise you of the special privileges.
How could
that are
they not
enjoyed by
believe what
all
I
jurors.
said?
No juror can ever be required to
I'm a
talk about the
physical
discussions that
therapist.
occurred in the jury room except by court order.
I'm so
For many
smart.
centuries, our society has relied upon you, a jury, for consideration of difficult cases. For hundreds of years, we have recognized that a juror's deliberations, their discussions, and their thoughts and votes should remain their private affair for as long as they wish it. Therefore, the law gives you the unique privilege not to speak about your jury's work. Although at this point you are discharged with our thanks for your 6 days of jury service and are at liberty to speak with anyone you choose.
Guilty on
about
all
your
counts, toxic.
deliberations. You are also at liberty to refuse to discuss your deliberations with anyone you choose. A request to discuss your verdict or your deliberations may come from those who are curious, from the media, from elsewhere. It is entirely up to you whether you decide to preserve your right to privacy as a juror. I have an acknowledgement form that the deputies will hand out that will acknowledge your 6 days of jury service. It includes a business card if you are curious as to any additional
These are the real
court
tears
hearings.
now.
As a result of the verdict, you may contact my judicial assistant and she will apprise you of any continuing hearings. If you will delay for just a moment in the jury deliberation room, I'd like to return these
He's going to say
verification
something.
forms
I don't
with
think he's
my
going to stay
thanks. So I
quiet.
know you're eager to get home, but if you'll please delay for about 3 minutes, I'll be back there to deliver these to you. Thank you.
All rise for the jury, please.
You're welcome. You're welcome, Toxic. Oh, gotta give the people what they want. Gotta give the people what they want. The real tears.
Mr. Todt, a jury has unanimously determined, after being selected from our community with your participation, that you are guilty of murdering your wife, Megan Todt, of murdering your daughter, Zoe Todt, murdering your son, Alexander Todt, of murdering your son, Tyler Todt, and murdering the family dog. State, you anticipate a sentencing hearing wherein the family will be allowed to give a statement.
Shakes his head any hard, it's gonna fall off.
Are there any additional family members that wish to give a statement? All right, thank you. Defense, is Mr. Todt entitled to a pre-sentence investigation?
He would be, Judge, but given the circumstances and the only punishments allowed by these verdicts, we think that that's not necessary.
Thank you.
Yep. Getting that LWAP.
Court is going to take a 10-minute recess to allow the parties to prepare any statements prior to sentencing. Sentencing will commence in approximately 10 minutes.
May I ask, Judge, do you require the presence of Mr. Todt?
Yes.
Yeah, he's gotta be there for the sentence. That's well, we're gonna do sentencing in 10 minutes. We're gonna do it live. There is no sentencing date. The sentencing date is today. Young Anthony is going to meet his destiny. Well, Shaw, there's no point in they sentence quick. It's mandatory life without parole. So there's a mandatory sentence that has to be imposed by law. So dragging this out for a couple of weeks to argue in a sentencing memorandum doesn't really help anybody. Dang, where the hell did everybody go? Oh, everybody's taking a 10-minute break or something, I guess. But yeah, there's no point in there is no point in waiting. This is kind of like, why not? And I don't blame the judge. It gets everything done. Yeah, I think, Shaw, you're right. It probably was the last count. I think it was the last count about the dog, but who knows? Well, maybe we'll find out at some point. Um, I'm probably gonna go finish some things up and finish my dinner. But try to see if anybody's got any questions. Yes, he has to be there for sentencing. You don't have the right to not be present. That actually happened here in Ohio. There's been a couple of cases like by law you have to be there for your sentencing. Katie did, yeah. Welcome back. Haven't seen you in a while. Hello, Cameron. KLF, good to see ya. Yeah, but everybody else, yeah, he has not lost his mind yet. I'm surprised. Give him a chance to go to the bathroom. So, real quick. Yeah, fifth count was cruelty to animals. No, because part of like your sentencing, you got to be there for that. If I was a judge, I'd want that person to be there for their sentencing. It's your last chance to speak. You're the last person to speak before sentence is imposed. I don't think legally you should ever be allowed to do that. I just don't think legally you should ever be allowed to waive your presence at a sentencing. You got to stand there and pay the piper. It's his turn to stand tall before the man, and guess what? He's going to stand there. If I was a judge, I would never let people skip out on sentencing, especially like a felony cases. Yeah, Chandler tried to do it too. I don't think legally you should ever be allowed to do that. The only times I would ever sentence somebody in absentia was like if there was a consenting to like a parking ticket or a traffic ticket, something stupid like that. I think you can do that. Still shaking his head like he's stuck in like skipping mode. Shakes his head any harder, he's gonna look like Michael J. Fox. Oh, is he talking? Ooh, they shut the sound off so we can't hear. He is getting mad though. He's getting mad. That's him in your pic, right? Yeah, that's him in the picture I have on the thumbnails. Victim impact statements. Yes, if there's any family there, they'll be able to say like, but I mean, really, he killed his family, so I don't know. Yeah, he'll have it. Yeah. Oh, I don't think he'll be able to keep his mouth shut once it gets going. Guys, I'm gonna be away for 5 minutes. I'm gonna just turn this off for a second, off of here, so Law and Cuck does not get mad at me, and we'll be right back. Okay? That way they can't say I'm streaming right now. And I know I'm talking a lot more, but I want to give them no chance to say I'm fucking with their stuff. Just because they're dickheads. So I will be right back. Go get a drink and hydrate up, everyone. His neck cucumber. Oof. Jeez. That was not 10 minutes, you son of a bitch.
Case of the State of Florida versus Anthony John Todt, 2020 CF.
That was not 10 minutes.
149, based on the
Jeez.
jury's unanimous verdict as to all counts. The court will now proceed to sentencing. Does the state wish to present any testimony from the surviving victim's family?
Yes, Your Honor, the state will call Cynthia Todt.
Thank you.
Thank you, Judge.
I don't think she
Okay.
sworn for this portion.
Thank you, Judge, for hearing me. My name is Cynthia Kopko. I am Megan's aunt and godmother to all her children, Alexander, Tyler Bear, that's what I called him, and Princess Zoe and Breezy. I just want to say that Megan lived her life. She had lots of empathy for everyone. Thank you. Lots of empathy for everyone. She had a giving heart. If her neighbors were sick, she would make them soup and bring it over. The kids were very, very talented. They played the piano. They would go, for years, they would go to convalescent homes and play recitals for them on special holidays, and they were in a lot of musical staged things. And
Like stage
when
murder scenes.
Alek wanted to learn how to play the violin, as they were learning, and Tyler Bear wanted to learn to play the folk guitar, they would still bring those instruments and play them for the people in the convalescent homes while they were learning them after their piano playing. They were very much, I had so many neighbors in the condo tell me how wonderful the boys were and Megan was, and how the boys would babysit and walk their dogs when they were away, and they trusted them fully. Megan and the dog and the children would go on for several walks, and she was very much involved in the academy school that the children went to, and did lots and lots. She was a physical therapist too, and did lots of projects and how all the fingers work with the tendons, and she had made strings so they could see how our hands move for a learning experience. And you know, I got them a microscope because I'm a nurse, so they could see different things in the microscope. They were just fun-loving. And all the children, I just have to say something about the communities that were affected. All the children in Celebration that they played with, they had a beautiful basketball hoop, which was donated to the children, and they're going to make a little monument thing out of it.
That's actually touching.
The children would ask their fathers, "Are you going to kill me at some time? Do you think you're going to kill me?" Because the children were, Megan's kids were just so fun-loving and giving and loved all their friends and they came to the house, they did all kinds of things together. Went in the little playground areas and climbed things and slid and played games. And that's a lot of trauma for a child to ask their father, "Are you going to kill me too?" So they have to deal with those things now, that community. He crushed my parents. To the children, my mother was the great-grandmother, and they just loved going over there. My mom is 95 years old. And, you know, we watched them grow up, and my father is 97. He has PTSD from World War II. Love the kids. They would take Megan and Tony on vacations, just like family is family. But for a horrific tragedy like this to happen is a nightmare. It's been 2.5 years. I used to take Megan and the kids all on different vacations to Disneyland, and each child, each year, got to pick where they wanted to go, and we would go. We'd pack up and everything. Tony crushed his whole family by doing this. Everybody was mortified. We had a tough time dealing with it. I guess pretty much that's about it. But Megan was the gentlest person. She wouldn't even kill a bug, and she was just so kind, full of empathy. And I had warned Megan many times when we used to have things called girlfriend days, where it would be my mother, Megan, myself, and the kids, and we would say, we're going out for the day and we're going to get shoes for all the kids and we'll have lunch. But we'd get called and she goes, oh, that's Tony. And I said, don't worry about it. We're in the middle of a conversation. 5 minutes later, he would call back again. And she said, oh my gosh. And then she would decline. And then he called me over and over just to get a hold of us to see what we were doing, where we were. And I picked up my phone and I said, stop harassing us. We're having a girlfriend day. You'll be the first to know if we're having any trouble. You'll be the first one we call, so that we could enjoy our day. And April of 2019, I had a talk with Megan because Tony had put on tremendous amount of weight over, a short period of time. And I said, Megan, I'm worried about Tony because he's put on so much weight. I would love to offer him to get ultrasounds of his carotids to make sure there's no blockage, and also of his heart and the coronary arteries to make sure there's not plaque or anything. And he always complained about his legs hurting. So I said, perhaps maybe he has a aortic aneurysm, which is like a weakening of the wall. Maybe he's not getting enough blood circulation, because when he would sit down, he would just totally fall asleep. I hope I'm not boring you. But we loved Megan and the kids very, very much. And all I have is pictures and memories I can hold in my heart. And my parents miss them, and his parents miss them, and our families miss them very, very much. That's it, Judge.
Thank you, Ms. Cobb.
Thank you for listening to me.
Any additional survivor family victim statements? Does the defense care to give any statements prior to sentencing?
Do you want to address the court?
Come on. Do it.
You want to address the court. Shall we come to the lectern?
He can address the court from counsel table.
You just move the mic closer.
He's welcome to stand.
Let's hear it.
This was a personal catastrophe in everybody's life in my family, including myself. I maintain my innocence. I provided for my wife, did everything I could for my wife. She was progressively sick over the years. There were days which were worse, days which were better. She was kept on a pedestal from me. My kids I did everything for them. The weight gain, Ms. Kopko has said, was because I negated myself. 2 to 3 hours of sleep a night because I would be treating my wife, doing for my wife, flying back and forth. I appreciated her medical concerns, and the reason why I would call so much is because Megan would have bad days, and I just needed to know she was okay. It wasn't a control factor. It wasn't any kind of...
It wasn't a control
scoping
factor,
things
but
out or
it
whatnot.
definitely was a control
factor. It was my fear that she was, or my fear that something was wrong with her, and I just needed to hear her voice making sure she was okay. I loved my wife. I loved my children. I was not there the night my children died. The kids and my wife woke up. Sorry. The Friday before all this happened, we got in a disagreement, and I begged her to go get help because she screamed at my son because he didn't do the pot, clean the pot. He let it soak per my instructions. This has been a progressive history since the miscarriage, her anger issues, her frustration issues, and it was directed mostly at me. And I took it. It's okay, because she held me partly responsible for getting her sick initially because I insisted she went to the hospital. I told her, after she finally decided to schedule a doctor's appointment on the Thursday after Thanksgiving, she canceled it. I found that out the night before. When she screamed at Tyler, the Friday the 13th, I told her that she has to the end of the month to see a doctor because she went to the alternative and spiritual and all this other route. Or I would get her aunt and my sister involved.
You have to the end of the month or I'll kill you.
After that, she once again held it quiet in public. Okay? She was very good at keeping it from the public. We went to the recital that they did for the convalescent home on the 13th. I was walking on eggshells. I don't like upsetting my wife. My wife was primary and foremost in my life, especially after she got sick. Finally, whatever day it was, and I apologize, I do not have the days because I was on a winter break. I went up to her one night and said, listen, I haven't treated you in a couple days. Just allow me to treat you. Allow me to work on you. And I tried a couple different techniques. As I was working, she was worried about me not loving her anymore. And I told her, no, the footprints, remember the footprints poem? Sometimes you don't think I'm there, but I'm the one carrying you. I will do whatever you need to get ready.
I'm the one
That's why I've
carrying
supported you. She knew I didn't believe in this light and this other religion that she went into. But I supported her, because that's what a husband does. Everybody has a freedom to choose their own religions. Everybody has a freedom to choose their own acts. She fell asleep, very rested comfortably. I couldn't sleep. I went downstairs.
And I got my knife sharpened.
Okay?
Judge Carson doesn't have the authority to overturn the jury's
No, I understand,
verdict.
but I need to let him know that everything was okay when she woke up the next morning. I kept the kids out there to keep outside to keep her nice and stress-free. That's the only reason I left to go to the condo that night, because everything was good and there was an opportunity to get things done. As Ms. Kopko said, I fell asleep at a drop of a hat. I have this weight off my shoulders that my wife was feeling great. I went to charge the phone, and I fell asleep. I woke up afraid to be on eggshells or the doghouse again because we just reconciled. I ran back because I could not get the car started. It turns out my seat was too far back. And after that, everything happened. And I lived nothing but a nightmare. Every single suicide attempt, every single nightmare would come out. I relived every nightmare, would wake up, and would see, I was like, oh, that's a nightmare. Would see my family dead. I progressively tried to kill myself over and over and over again because I wanted to be with them. This altar they speak of was a homeschooling project from the week prior. That's all that was. There was no religious seance or anything whatsoever. It was nothing but a homeschooling project that made my wife happy because we were talking about Egyptian pharaoh and pyramids. That's all we were talking about and what they bring in the afterlife.
This is not helping you from this progress on, so I encourage you to.
I'm sorry. I love my wife. I love my kids. They were first and foremost in my life. I did not do this. I provided for my wife, provided for my kids, did everything I could. I understand the jury came back. I understand evidence wasn't heard. I don't remember that time, from the time I fell down the stairs to the time I woke up in the jail. I love my kids. I love my kids every day. It's only recently that I just stopped crying myself to sleep. My kids and my wife were everything to me. They were the center of my universe. When I came home, I was shattered.
Well, I'm sure you were.
I appreciate you listening to me, sir. And I know you're in your situation.
You're in your situation.
I did not.
Bro, you're in
do
your
this.
situation.
Thank you for listening to me, sir.
Any additional witness or testimony?
Only one situation we know.
Thank you. Court has been present during the presentation of evidence throughout the entirety of the trial. A jury has unanimously determined, after listening to the evidence presented, that you, Anthony John Todt, are a destroyer of worlds, that you destroyed the world of your 4-year-old daughter, Zoe Elizabeth Todt, that you destroyed the world of your 10-year-old son, Tyler John Todt, that you destroyed the world of your 13-year-old son, Alexander John
powerful.
Todt, that you destroyed the world of your wife, Megan Denise Todt. The jury has unanimously determined that you murdered each of them with premeditation based on the evidence presented in this room. As to count one, first-degree murder of Zoe Elizabeth Todt, you are sentenced to life in prison without the possibility of parole. As to count two, for the premeditated murder of your son, Alexander John Todt, you are sentenced to life in prison without the possibility of parole. As to count three, for the premeditated murder of your son, Tyler John Todt, you are sentenced to life in prison.
Ooh.
As to count four,
for
the premeditated murder of your wife, Megan Denise Todt, you are sentenced to life in prison.
Oh, stop the fight.
One of those lives was less valuable than the others. Those sentences will be imposed consecutively. You will be adjudicated guilty as to each count. For the murder of the family dog, you are adjudicated guilty and sentenced to the maximum sentence consecutive, which is 1 year in the county jail. You will get credit for any time that you have already served. Madam Clerk?
Well, at least he's got a year down.
19 days.
Any costs will be reduced to judgment. Reserve as to amount pursuant to statute. You have 30 days from today's date to appeal this judgment and sentence. If you wish to do so, you must do it in writing. If you can't afford an attorney, one will be appointed for you.
You can reach out to me, bro, but I don't know if I can help
you.
you.
To the Department of Corrections to serve your sentence. Anything further, State? Anything further, defense, at this time?
No, Your Honor.
That will conclude the trial and sentencing process. The State of Florida versus Anthony John Todt has concluded.
So that's it, sports fans. We are done. So guys, we're just gonna go for like a couple more minutes. Yeah, later's all. Yeah, we're just gonna do this for a couple minutes. We'll cover this tonight. We got time to cover it. Yeah. Hey Zulu, how you doing? Nice to see you, Charles. Nice to see you. Oh wow, we got a bunch of people showed up all of a sudden out of somewhere. Jessica Gerwels, hello. I don't think I've seen you before. Welcome. 4M, how you doing? Katie did. Everybody else, thanks for sticking around. So yeah, 4 life sentences back to back to back to back to back, and then 1 year for the dog, which he's already served on. So, yeah. Who was it in here that asked that question? Okay, Jessica, you asked this, and this is a good question. At some point, would the judge cut him off from a legal standpoint? At some point, the judge can say, like, sir, you need to, like, wrap this up. But that wasn't really that long. And for a quadruple homicide, first-degree murder conviction, This judge is going to make sure this doesn't come back for any reason at all. So he'll let him run his mouth like a boob for a little while. Why not? It doesn't hurt anybody. It just takes up a little more time. It's already past 7 o'clock, so what's a couple more minutes? I mean, if he had taken like 15, 20 minutes about it, the judge may have said, okay, please can you focus on what sentence I should impose, instead of telling me the whole history of everything. But in this little bit of time, that wasn't too bad. But also, it didn't matter to the judge because, sure, let him talk. I can't change anything. The only thing the judge could have done is run, I think, maybe the sentences concurrent, but they're still life sentences no matter what. So let him talk. Can't hurt anything. Can't make it any worse. That was a really, yeah, it sounded like he was changing his story again. That was very powerful from the judge, and that's the thing. You don't have to be Judge Borowski and like, you can be quiet and tough. So, yeah, so guys, that's going to be it. 9:30 tonight, we will be back again to live stream. So, we'll talk about that. Interesting things we could talk about. Anything else you guys want to talk about? Oh, well, thank you for coming by from Legal Bites. I appreciate that. I appreciate that. If you like me, you like and subscribe would be great. I will be back on at 9:30 tonight, and we can talk a little more then, guys. So, at least we ended on a good note. So, Sky Queen, thanks for stopping out again. Barrisone, not guilty, all counts. We'll talk about that one. But yeah, we're covering everything. I put a thing up on community post about what we're covering. Yeah, thanks again, everybody. Great job, everybody. I appreciate it. Yeah. Oh, yeah, we're going to talk about Marcus Wilson. That's coming up. If I don't bring that up, spam it in chat so I see it. I'll make sure to try to cover that, though. So you guys... Off to sleep, Matthew. Yeah, you need it. Good, get some shut-eye, man. All right, guys. See you in a little bit. Shaw, once again, I think you were right ultimately, so give props where they're due. See you guys.